Recording.
Good morning, everybody, and welcome to the June 20th, 2025 Committee of Bar Examiners meetings. As a reminder, this meeting is being recorded. At this time, Devin, could you take the roll, please?
Dr. Bolton? Here. Dr. Cow?
Here.
Alex Chan?
Here.
Kareem Gangora? Larry Kaplan?
Here.
Paul Kramer?
Here.
Alex Lawrence?
Here.
Esther Lynn? Justice Misiwala? Joshua Montgomery? Bethany Peak? Vince Reyes?
Here.
Judge Reyna? Ashley Silva Guzman?
Here.
Julianne Smith? Alan Yokelson?
Here.
We have a quorum.
Thanks, Evan. Alan, before we go further, I just want to make the announcement that I'll be participating in today's meeting by video, but I'll be keeping my camera off because I'm currently at a hospital attending to a very medical emergency. As such, Mr. Yokelson, Mr. Vice Chair, will be leading today's meeting. Thank you, Alan.
Thank you, Alex, and take care. Our thoughts are with you.
Thank you.
Okay. A couple of reminders. As required by the Bagley-Keene Open Meeting Act, members are to appear visibly on camera during teleconference meetings, except if a member is unable to appear by video due to connectivity challenges. We ask that any members who are present with their cameras off state their names and reasons for not being on camera. Additionally, if a member joins the meeting after roll call, they should raise their hands virtually to notify the chair and the members of the public of their presence. If their camera is off, they should provide an explanation. Members should also raise their hands when leaving and returning to the meeting if they will be absent for more than 5 minutes. So next on the agenda is a call for public comment. Before we begin public comment, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items which are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the committee exercises oversight on admissions matters, including the California bar exam, the first-year students bar exam, moral character applications, and law school regulation. The CBE does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meetings. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments, and we thank you for that. To facilitate as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers. Additionally, we have a very full agenda for today's meetings. As the chair of the CBE, I'm going to exercise the option to limit each speaker's time to 2 minutes or to close the public comment period after 2 hours, which includes a 10-minute break, or after the first 100 speakers, whichever occurs first. And I will note that some of the members have received an accommodation to allow 3 minutes of comment. For those of you who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon, and it should appear at the bottom center of your screen. If you wish to address the committee, please click the hand icon now, and the committee coordinator will call on you in the order that the hands are raised. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then the number 9. Again, doing so will alert staff that you would like to make a comment, and the committee coordinator will call upon you and open your microphone so that you can address the committee. For those of you who are participating from a noticed location, please alert the committee member of the State Bar staff present in the room that you would like to make a comment. Staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash throughout the final 10 seconds. Committee members, could you please advise if there's anybody at your noticed locations? There is nobody in Los Angeles.
Good morning. This is committee member Julianne Smith, stating my attendance for the record as well. And there are no public members at the San Francisco office.
All right.
Nobody in Davis either.
All right. With all of that then, the committee coordinator will now call on members of the public who signed up in advance. Devin?
Our first public comment is from Dr. Tammy Keeley, who is not in attendance. Our second public comment is from Dr. Jonathan Mars, who is also not in attendance. Our next public comment is from Benjamin Cohn.
And Mr. Cohen, you have 3 minutes to speak. Please go ahead.
Thank you. I am speaking in behalf of an applicant, Jimela Castro Gallo, who I believe is also going to be commenting herself on related subject matter. I signed up both of us in advance, so hopefully you see her also in a couple of minutes. We understand we're not going to get a response in open session, and that this appeal has been moved to the July 9 meeting instead of this one, but we still want to raise to your attention that the consultant report that was given is not giving legally sufficient allegations, even if they're credited, to deny testing accommodations. There's no allegation that anything that the treating doctors said, for example, is incorrect. It's all just that they didn't explain XYZ well enough, that they didn't use the preferred evaluation instruments, which the law does not require, that they use different evaluation instruments based on a consultant's preference in that manner. And as such, there is absolutely nothing there to rebut the threshold premises that would, unrebutted, require that the accommodation be presumed the accommodations requested be presumed reasonable. There was no allegation in the decision letter that any of the accommodations at issue would constitute fundamental alteration or undue burden, and there was no demonstration that either of those exceptions would apply, both of which would have been required in the initial decision, not the appeal, in order to rebut reasonableness that way. For these reasons, we urge you to correct we urge Ms. Ching to correct the accommodations decision as soon as possible, because she can do that at any time. And we believe that that would narrow the issues that need to be brought in the coming weeks in the California Supreme Court. If it does go to this subcommittee on July 9, we urge you to give the appeal a very careful look and anymore.
Thank you for your public comment. Your time is concluded. Our next public comment is from Jean Millette Castro Gallo.
Good morning. Can you hear me?
We can.
Good morning. Yes, my name is Jamilet Castro Gallo. I submitted my testing accommodations petition on March 5th for the July exam, and the decision came back with a partial denial on May 7th. This is not the first time that I submit a testing accommodations petition. The difference now is that there is a neurological evaluation that had been requested, and I'm also represented by counsel. I don't know how to say it more clearly. I am exhausted by the continuous discrimination that I have faced because of my disabilities. This time, just as previous iterations, the consultants don't give any solid recommendations or background or evidence as to why it is that he or she is denying. I do have a combined ADHD diagnosis. My doctors have gone into detail about my combined ADHD, and yet the consultant just makes a statement that it is not a combined ADHD. It's absurd. I don't know how this consultant comes about making that statement without being my treating doctors. What I also wanted to say is that my doctors were going to be appearing in support of this administrative appeal, and but the dates were switched at the last minute, that instead of my petition being the appeal being reviewed for today, June 20th, it was, I believe, a couple of days ago that it's now being scheduled to be heard on July 9th. I ask you to please do the right thing and please look at the evidence that my doctors have presented.
Thank you. Your time is concluded.
Thank you, Devin. Before we go on, I just want to note that a member of the public has joined us here in Los Angeles.
Thank you. Our next public comment is from Terry Elliott.
Yes, good morning. Can you hear me?
We can.
Thank you. My name is Terry Elliott. I'm a February bar examinee who was denied ADA accommodations on the exam and denied provisional licensure because I took the exam once before. I came within a few points of passing, yet have no appreciable remedies to date. The California Supreme Court failed to grant provisional licensure to me and my similar cohorts. How can someone who never took the exam have a provisional license and I don't? I am talking to you today to ask you what you are doing about this injustice. Where is my zealous advocate? Additionally, in the last 4 months since the exam, the State Board of California has initiated a suit against Measure Learning. Time and energy has been devoted to prepare the suit, yet no similar time and energy has been devoted to provide me with a remedy for denying my accommodation. The bar has indicated I should expect to hear back from an independent consultant by September, a full 7 months since the exam. You have known about the lack of accommodations for 4 months. I ask you today, why does it take 7 months to address your serious infraction, yet only 4 months to prepare a lawsuit against the vehicle of this infraction? One plausible answer is that you want a remedy to compensate you for Measure Learning's failures, and similarly, I want the same from you. Why should you fail to address the ADA remedies before you sought your own remedies against Measure? Your duty is to us first as examinees. Thank you.
Thank you. Our next public comment is from D. Allen.
Hello, are you able to hear me?
We can.
Good morning. It has been a very long road these last 4 months. As someone who does have accommodations for the exam, I was a test taker for February. And besides, I mean, everybody's heard all the stories about it being a complete nightmare. But I was actually kicked out the second day and logged into somebody else's exam while they were taking the MBEs. And after 17 minutes, when they finally did get me back into the exam, everything that I wrote that day after that point is gone. I was unfairly graded And I know there's this investigation going on, but once this investigation, you'll see me on the video having a complete meltdown, and then yet half of that day and half of my essays actually are gone. So of course I get this fail, but how could I have gotten this fail if not all of my work is there? And as somebody who does have documented ADHD, the constant interruption and from the proctors and being yelled at by the proctors and all of these things that have happened. So I just don't feel like even with this independent investigation that's going to happen or that is happening, there still has to be remedies for us, right? So for every minute that I didn't get accommodated for, every minute that I was kicked out of, am I supposed to get what, 10 points, 5 points? Like, how is that going to work? It's really not going to. And I've lost a job now because of this. And waiting till September means I'm still needing to prepare for July. And that hotel and that all of those things, it's 4 or 5 days for me. That's almost $1,200 in just hotel fees. And that's not food, gas, or anything. So I propose that I obviously you're not going to give everybody who's got ADA's accommodations, but a 15-point bump on everything and a 20-point bump on the PT, I think is a
Thank you for your public comment. Your time is concluded. Our next public comment is from Tate Week.
Good morning. I request an accommodation of a 3-minute speech, please. Recently, I had a 30-minute speak with Sunil Gupta, General Counsel for Chief Justice Patricia Guerrero. During the call, I learned that when the Supreme Court ruled for the PT score imputations, they failed to have the data to understand that our PT scores will be lower than our essay average. What happens? International applicants have been severely disproportionately affected for that. They're going to lose their legal status. For them, it's not just about take the exam again. They will not have that opportunity. I have addressed this issue every time in every single meeting. Yet the CBE has failed to address even once this issue. If the Supreme Court is willing to get further remedies, why are you blocking that possibility for all the applicants that are losing just half a point, 1 point, 2 points, and didn't get the provisional license just because they had one prior exam? For international applicants, that's just because they try on the first time to understand how the bar exam works to get it better for the second time. You are disproportionately affecting international applicants and all those that are retakers. You're discriminating against them by not providing them a provisional license. I also suggested to the Supreme Court that it's more fair to impute scores from July 24, professional responsibility, performance test, and real property essays. And I know the pre-commitment, the same that used ChatGPT and put us in this situation, will argue that those are different exams. I agree. Those are different exams because July was a harder exam with a higher requirement for passing score and a lower passing grade. If you got a 75 in your professional responsibility essay during July, your score, it's more earned than any score you got on February with all these outrageous exams. It's more fair to get the scores that the applicants got in a normal condition, in a normal exam, than trying to guess what score they're going to have based on a psychometrically ChatGPT drafted methodology. And also in my case, I passed the MCQ portion, but still I got disconnected 7 times. Prior to that and after that, my skin was freezing. And all my questions were not saving. I lost more than 20 minutes, got 0 score imputation because I followed the bar exam instructions saying, don't let anything in blank. I am missing 4 points only to pass the bar exam. Should any of the 20 questions that I was not able to get score imputations have been imputed, I will have passed because I was scoring 70 percentile on the MCQ. All the people that tried hard to not panic and continue the exam independently on how much time they had or what circumstances they had, they have been punished. All those that failed to failed to continue, got remedies.
Thank you. Your time is concluded.
I have requested accommodation because of the language issue, if it's possible. I just need to add one more thing. I also request, please reconsider at least providing provisional license to at least those that got a second read and those that only have one prior exam. I'm sure the Supreme Court will be willing to accept that. And that will be all. Thank you so much.
Thank you very much. Next speaker, please, Devin.
Our next public comment is from Gerard.
Good morning, honorable members of the California Bar Examiners. I am a repeat taker that has been deprived of the provisional license that was passed by the California Supreme Court. I just want to start with one thing. We're not going away until we get justice or see justice for everyone. You cannot arbitrarily go and give a provisional license to new takers and deprive us of the same right when we're both exposed to the same harsh conditions. Why did you apply score adjustment remedies to everyone equally when it came to score adjustments? And then you decided the last minute to deprive everyone else who detrimentally relied on the impression that we will all be getting the provisional license. I would like to note that we're not going away. I want to keep saying this until justice is served. We will go away in one way. You pass everyone equally. You lower the passing score to 1250. Or you adjust impute the multiple choice questions to everyone across the board by at least 10% or 15%. Chad, the psychometrician, he stated that you cannot score the essays separately from the PT. Well, let me tell you something, Chad. When we took the exam normally, it's 3 hours in the morning and 3 hours in the afternoon. With all the delays, even if you're not under ADA classifications, some people have a limited amount of energy all day. When you delay the exam for an hour or 2 hours, you can't go use the bathroom because 5 minutes is 5 minutes. The lines are longer than 5 minutes. You deprive me of something that you should not deprive me of the solution or resolution of that. Also,
Thank you for your public comment. Your time is concluded. Our next public comment is from phone number ending in 5536. Do not see them in attendance. Our next public comment is from Modis.
Hello, good morning. Can you hear me?
We can.
I'm here to formally object to the scoring methodology used in evaluating my February bar exam, specifically how my performance test score was imputed. I do not accept the fairness or validity of a model that estimates my performance based on how other people performed. This was my exam and it should reflect my performance, not the average of a group. During the PT, I faced serious technical problems. I lost access to basic tools like copy and paste, highlighting, and other essential functions needed to complete the task effectively. Yet even under those conditions, I performed strongly and consistently on my written essays. If my PT score had been estimated based on my own essay performance, not the performance of others, I would have passed. Instead, the model diluted my results by tying them to a statistical prediction based on peers who may not have faced the same challenges or shown the same level of writing skill. This is not just a technical complaint, it's a fundamental fairness issue. Why am I being judged based on other people's weaknesses? Why wasn't my actual strength used as a basis for assessing my score? The difference between passing and failing in my case came down to just a few points. Relying on a peer-based prediction model rather than my actual written work is unacceptable. I'm asking for a fair and accurate assessment of my own work. That's a reasonable expectation and a right every applicant deserves. Thank you.
Our next public comment is from Ellie Shad, who I do not see in attendance. Next public comment is from phone number ending in 6718, who's also not in attendance. Next public comment is from phone number ending in 4936, who is also not in attendance. Next public comment is from phone number ending in 3748, who is not in attendance. Next public comment is from Lawyers for Fair Admission, also not in attendance. Next public comment is from phone number ending in 5985, who is also not in attendance. Next public comment is from Jessica Jacobs.
Am I heard?
We can hear you.
Jessica Jacobs, Law Office Study Program participant for 5 years and counting. I'm currently studying constitutional law and am genuinely confused. How can the Committee of Bar Examiners, a government entity and arm of the state, deny me for 18 months of legal study without any notice, no opportunity to respond, no hearing, and no reasonable explanation, as is required by due process? I was never shown the staff memo that triggered the denial, not even told of a pending denial, despite my repeated asks. Neither I nor my supervising attorney were given the opportunity to explain Tara's misunderstandings. In fact, my supervising attorney wrote a thorough letter, not mentioned in Tara's staff report and hidden on page 328 of the exhibits provided to this committee. There was no hearing, no opportunity for rebuttal, just a blanket rejection that wiped out 18 months of my education. In actuality, the alleged errors affected at most 3 months, and even those can be easily explained had I been given the chance. I've always been transparent that due to the bar's documented deficiencies in 2023 and 2024, I had to compile my past work in October 2024 with additional tech edits in April when the Supreme Court ordered the CBE to review the sessions. Nothing in the state bar rules prohibits non-contemporaneous compilation. I'm not asking for special treatment. I'm asking to be heard. I'm asking that the committee evaluate my work on its substance, not based on clerical errors, delayed compilations, or bar staff deficiencies. I formally request that the committee review the new and relevant information in my June 9th letter, information that was not presented to you at your last meeting. I hope to receive a reply as soon as possible. And in closing, I ask you to consider this. To deny a legal apprentice due process while they are studying due process is more than ironic. It is unjust. Please allow me to be part of the conversation that decides my future in this profession. Please just talk to me to make this right. Thank you.
Our next public comment is from Claire Solot.
Good morning. Please make sure I have 3 minutes on the timer. First, I want to express my thanks to all of you. Serving on CBE is always a big commitment. However, this year, the preparation for the February 2025 exam and addressing the aftermath have increased the time and work involved far beyond the norm. Next, I want to share why CBE's work is so important to me. In the height of the COVID pandemic, I created the Legal Service Funders Network Public Interest Bar Fellowship. Since that time, 150 new law school graduates from 10 local law schools have been LSFN fellows, and over 50 legal aid organizations have participated. In 2021, I was asked to present the LSFN Fellowship to the Blue Ribbon Commission. As head of the LSFN, I have been able to facilitate public-private partnerships for the state bar. And finally, I am an attorney and a member of the disabled community. As members of CBE, you have been given tremendous responsibility to help guide and oversee attorney licensure in California. In this role, it's critical that you are provided with facts, evidence, and information that is comprehensive and objective. The 2 members of CBE who served on the BRC have shown via their voting records, their dissents, their articles, and/or their verbal comments that they oppose any form of licensure besides the California bar exam. Most recently, Chair Chan at CBE's May 5th meeting again cast disparaging doubt and comments regarding supervised practice and attempted to limit CBE revisiting the idea of using the national bar exam. I do not have time to address all of the misleading comments. What I will say is there is much evidence that shows that supervisors have strict qualification, training requirements, and put their licenses on the line. Participants have fewer bar disciplinary issues and experience less workplace harassment than new attorneys who become licensed via passing the bar exam. The financial cost to participants and the state bar would be far less than the CBX. There is robust interest by employers to hire PLLs and PBEs, and close to 85% of the public support alternative licensure. As this committee moves forward and works on the future of licensure in California, I urge you to include a range of voices and make sure that you are getting balanced feedback and accurate information. Please read the PLL report and recognize that the BRC's recommendations for California to continue to have its own bar exam was made close to 4 years ago, at a time where there were many unknowns, both about the national exam and the complex and costly aspects of creating an independent exam. The court's prior order should not be seen as set in concrete, as the CBE chair wants you to believe. Over the past few years, we have seen the court modify multiple prior orders relating to licensure. Thank you so much.
Our next public comment is from Susan Bakshian.
Thank you. I'm Susan Bakshian, a professor at Loyola Law School, a Blue Ribbon Commission member, and an active California attorney. I speak today to briefly highlight 2 points. First, and perhaps most importantly, the Blue Ribbon Commission never endorsed the traditional California bar exam. Instead, the commission recommended deep reforms. And secondly, while many smaller jurisdictions lack the resources to do anything other than adopt next gen, California has better options, including the Nevada plan. To begin, I would like to note, speaking for the entire Blue Ribbon Commission is a mistake. Today, I share only my insights as a member who participated fully on a deeply divided commission. While the CBE currently has 2 members who served on the Blue Ribbon Commission, they do not reflect the full diversity of views, as they represent only a fraction of the 19-member Blue Ribbon Commission. The Blue Ribbon Commission submitted its final report in May 2023. Much has changed in the past 2 years after the commission completed work that began in 2021. While the Blue Ribbon Commission rejected the Next Gen exam, it did so because the National Conference of Bar Examiners could not answer questions about the subject matter coverage, which later changed, or provide any specific information about the exam format. Both the Nevada plan and the Next Gen exam now provide alternatives that meet the recommendations to focus on testing skills more and memorization less. The Nevada plan was approved only last month, 2 years after the Blue Ribbon Commission submitted its final report. The blueprint for the Next Gen exam was released only 3 weeks ago. These options, along with the portfolio bar exam, deserve attention now. I submitted additional written comments that address these issues in more depth. Thank you for your time.
Our next public comment is from Amira Mohammed, who is not in attendance. Next public comment is from Brenda Souza, who is also not in attendance. Next public comment is from phone number ending in 0910.
Good morning. Can you hear me?
We can.
Good morning. Thank you for the opportunity to speak. I was a February 25 bar taker. I'm a father of 3 kids, all under 10 years old. I have 2 brief points that I would like to speak about. My first point is that even after the PT imputation, I'm still 2.5 points short of passing. My PT score before the imputation was 60, which is 2 points above the state average of 58. My essays were an average of 66, which is 4 points higher than the state average of 62. And because of that, I have a 4-point upward adjustment. But instead of applying the 4 points to my actual PT score that I got, even with all of the disadvantages, the imputation was done on the state average, which resulted in an imputed score of 62. And that only gave me a 2-point increase and not the full point increase that I earned. Had the adjustment been properly applied to my own score, I would have passed the exam. This method unfairly penalizes applicants who performed above average. So the second point I have is applicants within 10 to 15 points, there should be an option to retake just the MBE portion. Dr. Chad did say that that was a valid remedy. Given the uncertainty of the scoring and the delays with the imputation and having to follow all of these petitions and speak out, it's just created additional stresses to even study for the July exam, which already puts us another unfair position. Thank you.
That concludes the members of the public who have signed up in advance to provide public comment. I understand we have a member of the public in the LA office that wishes to provide public comment.
Yes, he's approaching now.
Okay.
Sir, why don't you have a seat and turn on your microphone?
Now. Nope. Thanks. Good morning. My name is David Lindner, Lindner. I'm here to talk about several different things and concerns that I've had. I've had the privilege of learning, watching, interacting with many of you over the past year, and have gained a lot of insight. I've been very concerned that we have a lot of attorneys in this state, and we're not able to replace them at a rate with our own numbers that we know in terms of law school graduation rates. We aren't able to go ahead and have control over the education and the process by which people are disciplined, our ethics, our morals. So from the get-go, we're dealing with people that are foreign to our state, and I think that's a problem. I think that we need to generate more attorneys within this state, and it's part of the job of this committee to make sure that happens. We've discussed ideas, but nothing's really been implemented. We also seem to have a big issue with the state bar in terms of overall with the due process. I think that's a very valid issue, and because of it and our state's issue, I think it has to be taken up in state bar court. And I think the problem there is it's going to be inundated with all these problems and all these folks. Everyone has different problems and everyone's going to have their own separate case. I think that it's also important to note that with the Supreme Court's action, it's acted as a massive rebuke of the entire admissions process, and it's disgraceful. I think that it's important to note that when you go ahead and you fail people, when you discipline people, that you must come from a high ground. And if you abandon that, I don't know what you have left. But I find it to be unacceptable. We're only as good as the information we're given. This committee is made up of professionals who give us their time, and we thank you. But you're only as good as the info that you're given because...
Thank you. Your time is concluded.
Thank you very much.
We will now turn back to members of the public who have raised their hand to provide comment. Our next comment is from Kamla Rahman.
Can you hear me?
We can.
I'm respectfully urging the California State Bar to pass examinees who's received a significant passing score on their essay portion. The administration of the most recent bar exam had so many critical problems that materially affected our performance. The multiple choice section in particular was deeply flawed, reportedly including typos, inconsistencies, and suspected AI generation content that did not meet the standards expected of a licensing examination. In addition, the exam platform itself malfunctioned mid-session for many examinees, causing exam sessions to shut down unexpectedly. This led to confusion, time loss, and incredibly stressful testing environments as people looked around and spoke loudly, cried, and waited to be re-logged in through no fault of our own. The severe disruption caused by these issues were directly compromised of the integrity of the MBE section and place examinees at a serious disadvantage. And it's very unfair considering that people who left their answer choices blank or people who were seen outside in the hallways and testing locations cheating, they probably passed, and we didn't, those who sat there in good faith and took the exams. In the interest of fairness and to preserve the credibility of the licensing process, we ask that these candidates be granted passage. The California State Bar used in their own words, said 58% of the in-person test takers surveyed reported issues with Measures provided computers, with 60% reported that the testing room was excessively noisy. So please pass everyone who did well on their essay portions and was considered for a second rate and who didn't do well on the MBE due to Measures and State Bar's failures. We need remedies for the multiple choice questions, considering you guys were able to give people who took the mock exam an extra 40 points. Why aren't we given extra points, considering we took an experimental exam as well and pushed through our given circumstances? We aren't asking for special treatment. We are asking for what's right in what the California Bar has done in the past. Thank you for your attention and consideration.
Devin, let's the record reflect that member Kareem Gangora has joined us here in LA.
Thank you. Our next public comment is from Ryan Burnham.
Yeah, hi. Can you hear me?
We can.
So I brought this comment up to someone that works at the bar before. Last meeting, there were a bunch of comments about people that were given a second read, and I found that to be like super arbitrary because some of the testing conditions that other people, I myself, had did not allow. If you have 45 minutes less time, 50 minutes, and your work is not able to have a second read, why is that person's difficulty or trials viewed as not as significant as someone who didn't have that and was able to write a full PT? I'm just not quite sure. It seems very arbitrary, the imputations, and where's the guideline? Like, where's the red line? Because I don't see how, with everyone's different situations and difficulties, where's the objective, the mean? There can't be one, and so I'm confused as to how these decisions are made.
Thank you for your comment. Devin, our next speaker.
Our next public comment is from Adelia.
Can you hear me?
We can.
Thank you. My name is Adela Toderian. I am a taker of the February 25 bar exam. I'd like to ask you to reconsider the provisional license to include repeaters. Repeaters are not second class or lower class than the first time takers. If anything, sitting for the bar exam multiple times, it shows perseverance and real dedication. I personally was 1 point away from the second read, so I did not qualify for any of the remedies. Would I have qualified for a second read? Maybe I would have passed because I had a passing score on all my essays, overall a passing score, but I failed because of the multiple choice questions. During the second day of the exam, after 100 questions, I had a nervous breakdown because every time when I was trying to save an answer, I got a message, your answer cannot be saved. And I had to go back, read the question again, and choose the answer and submit it again. Despite that, I kept pushing to finish the other 100 questions, to not leave anything blank as I was told. Obviously, the emotional distress state I was affected my performance. So due to the flawed questions, the system errors, and the emotional distress I failed the multiple question part. And I have not received any score imputation or other remedy. As my experience, there are hundreds of other people who experience the same thing. We are not asking for a free ride, but just for fairness. And what was promised to us, at least a provisional license, so we can prove that we are competent to work in the legal field, same as the first time takers. If not, at least lower the score to a 1250 or however will be fair to everyone. Thank you very much.
Our next public comment is from Dan Molina. You've been unmuted. Our next public comment is from Ray Hayden.
New mouse, sorry about that. I see people here in attendance from the CBE and staff that I have a great lot of respect for, because I know you've been through. Yep, Cody, you too, and I know that and Audrey, and I know that you. I went back and reviewed all those meetings. The exam from February wasn't just out of a hat. It didn't just happen. You worked for a couple of years on it, and I see that, and I was at all those meetings or reviewed them anyway. So you're used to my name. But the other thing is that I understand that there are a couple of people that want to see the NCBE Next Gen Bar Exam. I sent in a public comment letter. That's a number of pages. And basically the Supreme Court said, don't do it. So doing it now would be like a slap in the face of the Supreme Court. So that'd be fun. And there's a couple other major problems with it. But the biggest one is like in the BOT meeting recently, our Board of Trustees meeting recently, Mr. Harrison, Ryan Harrison, trustee, said that he would like to see the exam given more than twice a year. That erases the Next Gen Bar Exam. It can't be done because they only give it twice a year and they control that. California has been mandated to control their own exam. I highly agree with that. And the law says there has to be an exam. So you're kind of stuck with not being able to offer a PLL program pathway because the law has to be rewritten to allow that. And I get that too. And that's why the California Supreme Court keeps slapping those things down. It's an exam that you already have, and you have the contract with Kaplan. You don't need to have the written portion because that's subjectively graded anyway, which is really bad on a high stakes exam. And in order to have it more than 2 or 3 times a year, multiple choice questions, not exactly what I would want, but yeah, you can have multiple choice questions only. You do it with the first year law students exam with great increase in results. All right. So I'm running out of time, but I had more. So thanks a lot for your time and effort. Have a great meeting.
We'll go back to Dan Molina. Dan Molina, I see you've unmuted yourself. Would you like to start your comment? Our next public comment is from Lauren G.
Hello, can you hear me?
We can.
I'm writing to express my deep frustration regarding the inaction surrounding the ADA applicants, as I am one, and I can see the ongoing delays addressing our concerns. The fact that the BOT has yet to finalize the HMRO contract raises significant issues about the urgency of our situation. Leah Wilson's comment at the recent BOT meeting highlights that HMRO does not even have a proven track record in handling ADA issues, further calling into question the appropriateness of this engagement for our needs in addressing the accountability of these critical matters. Moreover, the state's general counsel's assertion that during the BOT meeting that an ADA claim applicant could not transition from a fail score to a passing one is not only disheartening, but deeply misinformed. Many of us are incredibly close to passing, just within 15 points, yet we continue to face barriers that are systemically overlooked. This is a substantial number of test takers who could achieve success had appropriate accommodations been implemented. Research constantly shows that timely support makes a significant difference in outcomes for individuals with disabilities, yet such measures remain unimplemented for us. We implore the CBE to take immediate action before the upcoming July bar exam. Providing a 20-point bump to all ADA applicants with a claim is a crucial remedy that can help rectify the situation, leveling the playing field for those of us who are striving to succeed despite the unique challenges we face. Such an initiative aligns with best practices observed in other jurisdictions, where similar adjustments have effectively reduced barriers for students with disabilities and led to a more inclusive environment. Finally, it is essential to emphasize that ADA applicants deserve immediate attention and actionable solutions. We cannot continue to be overlooked and left without support. It's imperative of the CBE to recognize us with a priority and act swiftly to address these injustices. Please do not delay our rights any longer. We need you to stand up for the ADA applicants and take decisive action now. Thank you.
I'd like to note for the record that member Esther Lynn has joined the meeting. Our next public comment is from Jana's iPhone.
Yes, can you hear me?
We can.
Thank you. Can you please allow me 3 minutes based on my accommodation?
Yes.
Good morning. Thank you. Good morning. I'm one of the applicants directly impacted during the February 25 bar exam. Even though I was granted approved accommodations, I faced multiple issues. During the MCQ session, my file was missing. The proctor was unable to assist and instructed me to contact the state bar myself. While my exam clock continued to run, I successfully retrieved my file, but lost a significant amount of time in process. I was physically and emotionally drained. With tears in my eyes, I rushed through the MCQ session, randomly filling in answers out of fear of leaving anything blank. I repeatedly asked the proctor to adjust my time, but my requests were ignored. I felt like I was in a battle I had to survive. It brought back memories of running from collapsing walls during the Armenian earthquake as a child, and of family fleeing bombs during the war in Ukraine. As I circled my answer, I kept telling myself, I have to survive this too. On May 5th, I learned I passed the essay with high scores, but failed the MCQ. Because of that, my exam wasn't second read, and I was excluded from available remedies. I was also denied provisional licensure simply for being a multilingual risk taker who took the exam early to gain experience and support the system, granting my future license. Today, I respectfully urge you to consider the following. Specify when and which remedies will be provided to affected applicants with accommodations. Amend to provisional licensure to include all repeaters, or a one-day NCBE and B exam for February 25 repeaters, or a reduction of the scaled score to pass all. You have the power. What you decide today will define our tomorrow. Thank you.
Thank you. Our next public comment is from KS.
Hi, good morning. My name is Kathleen Scally. I've gone back to the math and I've looked at the math. Here's how it worked. You guys first came to the bar before even the test happened and said, I'm sorry, to the Supreme Court, hey, we're giving a new test. It's going to be totally different. And I quote, part of transitioning from the MBA, the California Bar Committee will need to set a new raw score passing score. The examination and future bar examinations would be statistically equated to the expectations of the February 2025 bar exam. I'm going to go on. Then you guys hire validation panels, one for the written part and one for the multiple choice part. You put the multiple choice validation panel of 6 people in a room, and Dr. Becknell says to them, and I quote, hey guys, guess what? We expect, based on the last 2 years, that the multiple choice questions will be between a certain number and a certain number. The exact numbers he gives them are, well, first we're going to take out 25 questions to be in line with the MBE, even though we're not in line with the MBE. Then Bucknell throws them in a room and says, hey, by the way, based on the last 2 years, you guys should come out with a range of 100 to 124 questions that need to be answered correctly. The panel actually overrides him and says, you need 133 questions to be a minimally competent lawyer out of 200. The bar examiners, you guys then decide we're going on our own and pick your own number. Then you guys put a second validation panel for the written part of this test in a room and say, how much does the minimally competent lawyer need to get right? That panel comes back with a number that if that number had been accepted, 1.8% of the people taking this test would have passed. So you guys go to Dr. Bucknell and you say, what should we do? We can't have 1.8% of the people pass like the panel that we put together hired. And Dr. Bucknell says, here's what we'll do. We'll
Thank
back
you for
into
your
it.
public comment. Your time is concluded.
I expected that would happen, not things everyone wants everyone to hear.
Thank you. Our next public comment is from Vincent.
Good morning. Hi, can you hear me?
We can.
Hi, great. I'd like to have 3 minutes because I'm an accommodated test taker, please. I requested it in the original email, but wasn't acknowledged. Okay, so
hold on one sec, Vincent. That's fine. But as a reminder to all public commenters, if you need an accommodation for these meetings, including in relation to making public comment, please fill out the form online that is linked in the agenda so we may review these requests in advance of the meeting. With that, Vincent, go ahead for 3 minutes. Thank you.
Thanks, committee member. I appreciate that. Just so you know, myself and other members, that are on this call have submitted the form online, but unfortunately have not been recognized. So I don't know if there's an error in recognizing people, but just so you're aware. Anyways, again, good morning, everyone. Thank you for taking the time. But let's call it what it is: injustice. You've granted provisional licenses to first-time examinees, some of whom didn't even sit for the exam. But you've excluded repeat takers, including those who scored as high as 1387. In what world does that make sense? A person who withdrew after not studying gets a license, but a repeater who nearly passed is left behind? That's not equity. That's arbitrary gatekeeping. We've watched this pattern unfold since February. One illogical selective decision after another, all cloaked in the name of statistical purity. Meanwhile, exam integrity continues to rot. Multiple members of this very committee called this exam unacceptable. But then you dragged out the remedy process. You let us believe relief was coming. You delayed petitions. You stayed silent while we waited in good faith. Jobs were lost. Time was wasted. Physical, emotional, and psychological damage is still compounding. And now what? I assume you're going to point the finger at the California Supreme Court. They narrowed those who will be eligible, you'll say. But let's be clear. This grave injustice still lands on you. You waited months to submit the petition, and we detrimentally relied on your assertions. You used the provisional license to reject considering other remedies, and now you ask us to move on? That is morally wrong. At every fork in the road, you've taken the path of restriction, denying second reads to those who cross the 1350 threshold following your insufficient PT remedy, refusing partial retakes, disregarding accommodated test takers, and now refusing provisional licenses to the very people who endured arguably the worst of it. You've chosen containment over accountability. Worse, you are acting profoundly cavalier with examinees' lives. And we see it. Your own psychometrician said a partial retake of the MCQ or PT was feasible, albeit difficult to make happen. Admission staff confirmed it might be challenging, but several times emphatically mentioned it was possible. The PT amputation was a joke that helped a finite group of individuals, and we know how much of a mess the MCQ section was. So what's stopping you to do the right thing at this point? We know the argument that you can't take one section of the exam and apply to another administration is false because you made it happen a mere few months ago with the March retake. So from here, it looks like another effort to cover up a failed exam at the expense of people's futures, and that's simply wrong. So I asked, what are you going to do about it? You have two options. Send a new petition urging the Supreme Court to grant provisional license to all February 2025 examinees, or authorize a partial retake of the PT or MBE in July 25, February 26, or July 26. Anything less tells the public that this isn't about justice or competence or protecting Californians. It tells us your priority is simply protecting yourself. Please do the right thing while you still can. Thank you.
Our next public comment is from MG.
Can you hear me?
We can.
Since February, we've been forced to agonize weekly over our futures, told to wait, told to trust, told to believe that provisional licensure would be there for us. It was presented as a stable remedy. Every other proposed remedy, retakes, appeals, etc., was built on the assumption that provisional licensure would catch us. We relied on that remedy in good faith, and we had every reason to. Here's the brutal reality for many of us. This isn't just about preparing for July. It's about being forced to delay our legal careers by an entire year. Because of this last-minute reversal, some of us simply can't prepare in time. Others can't afford to, so let that sink in. This mistake cost us a year of our lives. Let's also talk about how absurd the current ruling on provisional licensure really is. Somehow, someone who scored an 1100 on their first attempt is now a provisionally licensed attorney. But I, who missed the cutoff by 1.75 points on my second attempt, I don't qualify. And the scoring, it was flawed too. On May 30th, we were told the higher of 2 second reads from essays 1 through 5 would be averaged. Had that happened, I would have passed. Instead, 3 points were deducted from my average based on some vague, unexplained PCM comparative grading system. I was imputed at a 62, despite earning a 65 average on essays 1 through 5, just enough to disqualify me. Had I received 1.75 more points on the PT, less than my own average, and what I had every reason to believe I would receive, I would have passed, but I was taken just below the cutoff. And let's talk about the MCQ. I'm not an accommodated test taker, but I was denied a lunch break by my proctor on day 2. I was cognitively impaired, yet I pushed through. Had I been given a moment to breathe or recover like others were, I'm confident I would have passed the MCQ. I needed one more correct answer. That matters. Every point matters. And it was taken from me, not because I wasn't qualified, but because the system failed to treat me fairly. To the bar examiners, reinstate provisional licensure for all examinees, including repeat takers, or offer an MBE section-specific retake Chad himself said was doable, or a PT-specific section retake. We are dealing with an outcome none of us expected because of a Supreme Court ruling none of us could anticipate. We need a path forward.
Our next public comment is from Jamila.
Good morning. First, I'd like to thank each of you for your work, dedication, and continuous listening to the February 2025 bar applicants' grievances. From my understanding, the Supreme Court believed that the PT imputation was closer to each applicant's average, not multiple points lower. Since repeat takers cannot receive a provisional license, I implore you to consider applying each February 2025 applicant's average of their essay scores as the PT number instead of the imputed number given, analyzing each applicant's work based on their own merit and effort. Thank you.
Our next public comment is from Anetta.
Can you hear me?
We can.
Okay. Hi, thank you so much for meeting with us today. My name is Aneta. I graduated from Southwestern Law School a few years ago and have been doing everything I can to pass the California bar exam. I'm here alone in the United States. My entire family lives in Poland. That means I have to support myself financially while preparing for the bar exam. It hasn't been easy. Like many other applicants, I gave up everything to study for the February 2025 bar exam. I took 3 months of work. I stopped seeing my friends. I didn't see my ex-boyfriend. I spent all my savings to hire a tutor because I was determined to give it everything I had. And I did. I was ready. But during the exam, everything fell apart because of the problems I couldn't control. I faced serious technical issue. I couldn't log in. The platform froze during the performance test, and I couldn't highlight or copy and paste. Proctors interrupted me constantly during the MBEs. At one point, I was kicked out of the test and couldn't log back in for over an hour. Still, I didn't give up. I called the tech support. I got back in and tried to finish the exam, even though I had lost so much time. I reported all of these problems to you because I hoped you would take fair remedial measures. You did not. I didn't register for the July 2025 bar exam because many of us were led to believe that we might receive provisional license, but instead you awarded first-time takers and those who withdrew, while those who were determined were left with nothing. Some received provisional license with lower scores, while we who score higher and refused to give up were ignored. Where's the justice in that? You are punishing people who have been working hard and did not give up. Because I did not get a provisional license, I lost my job. I missed the deadline to register for the next bar exam. Unemployed. I've been living in a converted garage with no kitchen, no shower. I showered at my friend's house. This is not the life I imagined when I chose to go to law school. I gave up everything for this exam. Can I finish? I'm not a native speaker and I have accommodation. One more sentence. Please, I'm begging you, consider offering provisional license to applicants who are close to passing, like me. I missed 3.5 points, or at least give us the option to appeal. Please, I don't want to give up on law, and we're people, we're not numbers, and the decision you make deeply affect our lives. Thank you.
Our next public comment is from Natalie. You've been unmuted.
Hello, can you hear me?
We can. Your volume's a little low.
Can you hear me?
Yes, we can.
Hi. I wanted to respectfully request that essays be averaged without applying the psychometric imputation to the PT. With just the standard average, I would have got a 65 for the PT scores, which would have allowed me to pass. However, I was given a 62 without understanding how this was calculated. And I'm asking if you would consider using a standard average instead, or at least reevaluating the PT imputation in light of the circumstances. That would be much appreciated. Thank you.
Our next public comment is from Pedro.
Hi, can you hear me?
We can.
Hi, good news, everybody. BART retakers have found a solution for this crisis. Good morning, my name is Pedro Crespo. Thank you for the committee to allow me to participate and express my point of view. I am a BART taker who attempted the California BART 3 times, including the February 2025. In the name of a group of repeaters, I come today to respectfully propose 4 potential solutions that firmly believe will terminate this crisis once and for all. There are the following. First solution, we urge the California Supreme Court to reconsider its recent decision and extend the provisional license to all. This would allow repeaters to work and continue paying for the bar studies. Second solution, if that is not possible, we request 1-day MBE exam only, with the essay portion waived to obtain the full admission. In addition, to reduce half of the attorney's exam to attorneys from other jurisdictions. This will reduce the cost of bar investment. Solution 3, if neither of those solutions is granted, we request financial compensation of $75,000 per applicant to cover the past future costs of bar preparation, including tutoring, materials, lost income, and personal expenses. 4, finally, as last alternative, we propose a reduction of total passing score from 1390 to 1,000. Anyone who has earned a score of 1,000 or higher would be granted full license. We believe that implementation of any of these 4 solutions will allow us to move forward, shake hands, and return to our work and studies. It would also allow the California bar examiners to rebuild trust and stability and enable the Supreme Court to focus on broader legal challenges that the state of California is facing day by day. Thank you so much for your time and consideration.
Our next public comment is from Vikram.
Hi, my name is Vikram, and I was a February 2025 bar examinee. I would like to, I know that, the board decision on May 30th, 2025, candidate who scored between 1350 and 1389.99, they were not granted a second read. But however, it appears that the other candidates who initially fell within the same score range prior to the PT imposition were afforded a second read. So this discrepancy raises concern about the equitable treatment among similar candidates. So I respectively require the committee to consider extending the same opportunity for a second read to all candidates who ultimately scored between 1350 and 1389.99, regardless of whether score reached before or after PT imposition. Such a measure would ensure fairness and consistency in the application of board's remedial policies. Thank you.
Next public comment is from Raja. You've been unmuted. Our next public comment is from Geraldo.
Good morning. My name is Geralda Benga, and I sat for the February 2025 bar exam. This is a prayer for relief. I sit 2.5 points away from the pass score, and this PT imputation, had it been applied by the average of the 5 essays, would have allowed me to pass. This was just a miscarriage of justice. We're now in June. We are about 4 weeks away from the next exam cycle, and it's just disheartening to understand and believe that had I taken the February 2025 bar exam handwritten, I would have passed. The PT scores are unimaginable. Don't consider myself a slow typer, but I also do not consider myself a fast typer. We were not provided hard copies of the exam, as you all know. We had to work off of just one screen, though there was multiple libraries. The copy and paste feature was needed. It was needed, and we didn't get that. I was manually transposing words from one screen to the other, 4 words at a time. The time that I spent trying to transpose the law could have helped me craft a better argument to push myself to a 65. This is just disheartening. Had I handwritten the bar, I would have had a hard copy of the exam, and I would have had all the time allocated to me. And we still sit here 4 weeks away, 2.5 points away from the pass score, and we get remedies that are only meant to remedy outliers and not the ones that took the exam but could have used an extra 5 points, but for the fact that we were not given the functionalities we relied on. We would have changed our exam mode had we known that we didn't have something as crucial as a copy and paste feature.
Our next public comment is from Ray Hanani.
Hi, can you hear me?
We can.
Thank you for the opportunity. I kindly request accommodations and extra time because I have been approved for that. Hello, my name is Ray. I'm a February 2025 California bar exam applicant. Today, I appear before you not just as a bar candidate, but as a disabled cancer survivor, a caregiver, and someone who has fought against tremendous odds to be here, to where I am today, to be able to take the bar. I speak today to respectfully request either full or provisional license based on ADA violations, systemic testing irregularities, and denial of formally approved accommodations that directly interfered with my preference. I also request a provisional license for everyone to be treated equally, regardless of being a first-time bar taker or a retaker. I wish to be clear that my participation today is made under great emotional and psychological strain. I was asked to submit my medical information publicly as a comment, which I refused due to the confidential and deeply personal nature of my condition. Even being here to speak creates anxiety. Still, I speak because I have no other way to be heard to advocate for myself. Emotional and medical context of my situation is that I am undergoing active cancer treatment. I live with unpredictable fatigue, pain, and cognitive impairment. I also care full time for my elderly father with Parkinson's disease. I studied for the bar for months and months, spent thousands of dollars without working, without making $1 while navigating all of this with the expectation that I would be tested fairly under the American Disability Act. In July 2024, I was placed in a room in the middle of 2 blind examinees and verbal proctors. The constant verbal noise disrupted my focus and ruined my entire exam, caused psychological distress. I begged to be moved, and finally I was relocated. But by then I was experiencing a lot of anxiety and cognitive damage. February 2025, I was denied using restroom access. I could not wait, despite having these accommodations approved previously and throughout the entire law school, and even for February and July of 2024 bar exam. I was told I would be reported for a Chapter 6 violation if I had left my desk, and I had to stay with pain pain, fear, physical, and emotional trauma. The accommodations approved by the state bar were not honored. I was constantly distracted by the proctors. They constantly made me to move my camera and the lighting, even though I had accommodations to turn off and turn on the light. It is a civil rights violation. We all know the codings. I'm not going to go through those, but there are cases, the precedent cases, such as 42 USC, section 12132, 29 USC, section 794, 28 CFR, section 35.130, and 35.160. And then there is also the NER case. So these cases make it clear if accommodations were denied, the exam results are illegally valid, meaning legally invalid. Relief up to including licensure must be considered. Evidence of legal competence. I scored 1440 on the written portion of February 2025. That is not a borderline score. That is bar passing performance. That stopped me from passing. What stopped me from passing was the MBE, an exam administrated under inhuman, unlawful conditions. I'm not going to go through it. Everybody knows what happened to the MBE, and plus the ADA violations. So it is injustice.
Thank you. Your time is concluded.
I request an accommodation. Why medically unfit, psychologically not ready, and emotionally invalid. Be 8 more months without income or licensure. This is impossible. How can I do that? How can I support myself? How can I leave for another 8 months waiting? Nobody's going to hire me. I even lost a job that was based on PLL only. I told everybody I
Thank you for your public comment. You were given 3 minutes.
With the
We'll go back to Dan Molina. I see you have unmuted yourself. We still can't hear you.
Can you hear me now?
We can.
Oh, okay, great, thanks. You've since the beginning, and particularly after April, I saw this whole thing fall apart. You guys with this numbers, games, and these imputations, it's all fake. This exam could be graded, but never fairly. It's impossible to grade it fairly. The sanctity of the exam itself has been compromised from the very beginning. So, today I'm speaking on behalf of some of the repeaters that have been reduced to second class by the Supreme Court decision. We got 4 proposals, and we've sent you guys these proposals. Number 1, reconsideration of the recent California Supreme Court decision that has now rendered all past, present, and future repeaters second class by approving provisional license for only first-time takers. We want provisional licensures for everybody. Readdress this thing with the court, and don't do it in weeks, do it right now. Include everybody, out-of-state attorneys, ADA accommodated examinees, everybody. Or give us a 1-day NCBE, MBE exam. Or give us $75K. That's the least of it after these years. Or a reduction skill score from 1390 to 1000. I wanted to say, you got to lead with moral authority. At work, I impact people's lives. When I'm on the street, I lead with moral authority, okay? That's why I try to live clean, and I try to always do the right thing. You guys, from the very beginning, have not done the right thing, okay? You've lost your moral authority. Exams should never have been graded. You broke all sorts of rules by getting these questions in. Rules, black letter rules, okay? We're not going to go away. Okay, we've detrimentally relied. You've lost your moral authority. Regain it. Jump up and down and scream at the Supreme Court immediately. Thank you.
We'll go back to Raja.
Hey, good morning, good afternoon. Can you hear me, guys?
We can.
Awesome. Thank you so much, California Bar. You guys been setting up a lot of meetings. I really appreciate you guys listening to us. I don't hear a lot of people talking about the handwriters. I was one of them. To be honest, it was my first time taking the exam, but it was very difficult dealing with the people who were administering the exam within the exam room. Most of the time, I faced a lot of difficulty while, looking at the times and just them shouting out the time or calling out the remaining time, especially on my multiple choice exam during those days, and especially on the days when I was taking the essay exams. It was very surprising. I was given I saw that I had 30 minutes left, but I was told, hey, you have only 5 minutes left. That actually shattered everything in my head. And I was like, what should I do now? So instead of going through a regular metrics IRAC, which is like issue, rule, application, and conclusion, I was like, just be to the point, because I'm a lawyer. I'm already accepted lawyer in another jurisdiction, and we know how to overcome the question or how to answer a question. So if this exam followed the whole new concept of being online and with a newer method of examining the students, why can't we just go to the people who are basically looking at my answers and see that whether the people who are giving the exam or answers are to the point or not. Second thing, last minute I was told that I can't take this exam from my state. I'm currently living in Texas. I was like, you have to travel. And it was like probably a week before I was planned to take exam in Texas, but then I was like, I have to go to California. That cost a lot of money. A lot of last minute preparation could have been done, but I was unable to do it. And finally, my request to the dear people or whoever is there, I really appreciate you guys. I would highly request, no one is talking about it, if we can get a provisional license under a supervision, just take 10 seconds. Instead of a provisional license, which was given to the people in 2021 or 2022 at the time of COVID, which was like, you have to go sit for the bar exam again. But if we get an opportunity to work under a supervised
Thank you. Your time
learning.
is concluded.
Okay, thank you. So
we do not have any additional members of the public that have raised their hand on Zoom. I do understand there are members of the public in the LA office that wish to provide public comment.
Yes, are there members here in the office?
I think Viviana's directing them to the public comment table now.
She is.
Good morning. My name is Jose Castaneda. I'm the executive of the state of Felicitas Castaneda and Luis Castaneda, two estates, one of which was filed by what I call the female Thomas Girardi, because no attorney should file a conservatorship 21 days before a person dies.
Okay. Sir, I'm going to stop you for a moment. As a reminder, your comments should be focused on items that are on the agenda or related to matters within the CBE's jurisdiction. And discipline is not within CBE's jurisdiction or on the agenda
That's why I
today.
informed the individual that escorted me here, because I pointed out that other hearing next to, that was the right hearing, but he escorted me here, so it's not by my own fault.
I understand that, sir.
And let me just finish quickly then, that I filed accusations with the Supreme Court of California. The Supreme Court of California is, you are the arm, the disciplinary arm of the Supreme Court. And when we have the situation where the court...
Sir, actually, the CBE is not the disciplinary arm of the Supreme Court.
But there are a lot of people that are complaining because there's something going on.
Sir, I'm going to cut off your comments now. And I apologize if you were misdirected, but this is not the time or place for these comments.
Well, when is the right time to do it then?
Thank you. We'll discuss that off the record, but thank you very much, sir.
James?
Hi, my name is James Bloom, and I'm here for the public comment on the bar examiners. My only comment to you is, when the subject matter is, you guys are the bar examiners, okay? And you're looking for special people to represent us. I wish and I pray that you guys would focus on service. Now, there's a law on services. Service is the key, I believe, on the bar examiner's position that you should look into. Because if you're going to examine and you're going to get things done, they have to service. There's a law of services, and you should look that up. Without that, connected to the bar examiners to give us the service that we need. Now, I'm going to end it with this, and because some of you look bewildered, but it isn't, because there's a law on services if you look it up. The bar examiners have to hire people that give service. You're public servants, my God. Give us people to help us help you, and you don't do that. That's what I love about the military. Semper Fi, do or die, United States Marine Corps, for my God and for my country. You guys got to do this for your country. Please. The people need your help. Do it for country. I need your help. When you do these examiners, when you do these jobs to look for these examiners and to put these people in the right places, please tell them to provide service by law. Thank you.
Thank you, sir. And I believe that concludes our time for public comment.
That is correct.
All right. Once again, thank you very much, all the members of the public. We listen to these comments, we take them to heart, and we are trying to address all of the concerns here. One last time, I want to remind people, if they seek accommodations for public comment, please sign up in advance. That will facilitate the process. I think we've been going at this for almost 2 hours now. Let's take a quick break. It's 10:30. Let's come back at just 10 minutes at 10:40.
And Alan, just before you go, if you don't mind me jumping in, to the extent anyone has public comments relating to discipline, they can make those public comments at the next board meeting. So I just wanted to add that as well. So thank you, and hope everybody has a good break.
Thank you, Jean. Thank you. Be back in 10 minutes. Thank you. Devin?
Yes.
I had you there. There you are. I think we're all back. Why don't we get going again? Thank you. We're back in open session. I apologize. We're going to jump around a bit on the agenda today. So we're going to take the agenda in the following order to accommodate some of the speakers' or presenters' schedules. We're going to start with item 4.8, then item 4.4, then item 4.5, then item 4.7. And then we're going to go into closed session for 2 items, and then we'll return from that brief closed session, starting with item 4.1, and go through the remainder of the open, and then go back to closed. So I know that's a little bit disjointed. Please bear with us. But at this time, let's start with item 4.8. And Brady Dewar, the floor is yours.
Well, let me just.
And if you could, as we say in court, announce your name for the record, please.
Good morning, everybody, and thank you for having me, committee members. My name is Brady Dewar. I am an Assistant General Counsel in the Office of General Counsel. And before I begin, I just wanted to make note that analyzing and proposing the new federal legislation and rule changes at issue here in this item, along with me, were my colleagues at OGC, including Assistant General Counsels Joel Kim and Jennifer Sperling, and I wanted to thank them for their work, and they are available if we have some more technical questions. So I will go ahead, and I know we have a busy agenda today. So effective in December, a new change to federal law requires states to permit service members and service member spouses who relocate to a new state to practice law. We need to allow them to practice law if they meet a few basic requirements. These requirements for them to be eligible to practice law in their new state are limited to providing proof of military orders requiring relocation to the new state, providing proof of marriage to a service member in the case of a military spouse, and then providing an affidavit affirming, in essence, that they are in good standing in the states where they have a law license, that they understand the requirements to receive and maintain a license in the new state, and that they attest that they will comply with those requirements to maintain a new license in their new state. And finally, of course, that they are the person in the application and that everything they've said is true. So the way this federal statute is written is it is prescriptive. It basically says if the service members meet these requirements and do these things, then they need to be allowed to practice. So it doesn't allow a state licensing authority, such as the State Bar, to impose any additional requirements for admission or for permission to practice. It does, however, once they're in the door, allow us to treat them and require all the same things that we require of our regular licensees. So we're not allowed to add application fees because that's not in the federal statute. But once they're in, we can charge them their annual fees, for example. So our current RMA, we do have, since 2019, a statute providing for admission of military spouses who are here as a result of military orders. And so we've taken a look at that program compared to the federal law and found that there are some misalignments. Under the amended federal law, if we were to receive an application from a service member or service member spouse that met the requirements of the federal law, and we have not yet, that person would need to be permitted to practice with the same rights and responsibilities as a State Bar licensee. The current program does not provide a mechanism to effectuate that for all people. There are a few misalignments between the current program and the amended federal legislation. Those are that our current program does not include service members in addition to service member spouses, that it requires submission of an application for determination of moral character, that it requires supervised practice once admitted to the program instead of full practice, that it's limited to 5 years instead of the duration of the military order, and that it imposes additional first-year MCLE requirements. As I mentioned, once a person's in the program, they can be required to do everything, which would be, MCLE every 3 years. Our current program requires them to do all their MCLE in the first year, so we need to change that. As a result of this analysis in the new federal law, Staff, led by the Office of General Counsel and admission staff, have proposed an amended California Rule of Court 9.41.1 that preserves the parts of our existing program that don't conflict with the amended federal law, such as including civil unions and registered domestic partners in addition to spouses, while amending the program to allow participation by all who meet the federal requirements. The key changes to the existing program under the proposed rule are to include service members, to eliminate the application for determination of moral character, and I will note that the federal law allows us to do a background check, and that's essentially limited to making sure that everything that they've said in the application is true, that they actually meet the federal requirements, but we can't go beyond that to do the full moral character because as long as everything they've said in the application about meeting the federal requirements is true, we have to let them in. The amendments eliminate the requirements that program participants have an attorney supervisor, removes the limitation that applicants cannot have taken and failed a bar exam within the last 5 years, eliminates the 5-year time limit, eliminates additional first-year MCLE requirements, and adds a temporary licensure program. It adds a provision for the state bar to issue a temporary license 30 days after receipt of a complete application in the event that we can't complete the background check to verify their application. On that note, we did receive one question from a committee member that noted that the federal statute in allowing for a temporary licensure program uses optional language, permissive language. If the licensing authority cannot issue a permanent license within 30 days, they may issue a temporary license. And the committee member asked, well, why would we do that if we don't have to? And the answer is that that's basically a safe harbor that the statute provides. So without that temporary license, we would be in violation of the federal statute for not, once they provided us an application, immediately giving them a license. This provision is something that we're taking advantage of to allow us to complete the background check and verify that they meet the federal requirements. Excuse me. In addition, we did receive some comments from a committee member that led us to two additions, and we will have an amended resolution to cover these to the program as agendized. First of all, the committee member noted that we have a provision, and this is consistent with the existing Rule 9.41.1, that permits for military spouses a year of eligibility in the event of a divorce from the service member. So if they get divorced, they're not immediately kicked off. And this committee member noted that we might want to do that if the service member dies. And I think that makes a lot of sense, that if a service member dies, we're not going to kick them off the program immediately, just as we wouldn't if they were divorced. So we've proposed an amendment there in the resolution. And then the second change is that the current rule provides that your registration, your eligibility for the program ends if your relocation orders end. But it has an exception for service member spouses, that if you're eligible because you're married to a service member, and that service member is ordered transferred out of California, but they're not permitted to bring, it's a remote location and they're not permitted to bring dependents, then you can keep practicing as a spouse until the order's changed and you're allowed to go with your spouse outside of California. The committee member, Mr. Kramer, thank you, noted that because these orders sometimes come quite suddenly, you and your family, you're being transferred, you're leaving in 2 weeks, and especially because there's no longer an attorney supervision requirement, that we might want to provide a grace period to wind down the practice here in California. And so leave this up to you, but just in quick internal discussions, we thought 90 days might be reasonable. So, and again, we have a resolution prepared, but we would add to the rule a provision that if a service member transfers outside of California, the eligibility is terminated 90 days after that. I noticed also as I was looking at Mr. At the comments from Paul that so the existing rule, as I mentioned, only covers registered military attorney spouses, and this exception for being allowed to continue to practice in the program when the service member is transferred and no dependents are allowed to come. When we changed the program, excuse me, got a comment. I accidentally added I gave that exception to registered service member attorneys and registered service member spouse attorneys. That exception should only apply to the spouses, if that makes sense, because if the service member is transferred somewhere where out of California and not allowed to bring his dependents, he or she does not need to continue in the program. So that's another minor change to the proposed amended rule. And with that, two things I wanted to note, not on the slides. This preserves our ability, as mentioned, to regulate the program participants. Once they're admitted, they are still subject to our discipline requirements, MCLE, fingerprinting, the payment of the annual fees. And finally, I didn't note this on the slide, we also request a recommendation to, upon any Supreme Court adoption of this rule, to repeal the existing state bar rules pertaining to the registered military spouse attorney program, because those will be superseded by this new rule. And this new rule is basically designed to allow us to stand up the program, and if we later determine state bar rules are necessary or desirable, we would propose those. And with that, I will open it up for questions.
Mr. Chair, I have a question.
Question. Vince, hold on, Paul. Vince Reyes and then Paul.
Thank you for your presentation, Brady. I just had a couple questions. So let's say a service person is transferred out. So when and then there's that 90 days passes. So when they come back in, do they go through the process again of getting accepted?
They would, yes, go through the same process if they were ordered back to California.
Okay, is there some sort of, like, what if it was only 6 months or something? I don't know how the military works, but what if it was a real short duration? They would still have to go through the process of reapplying.
Yes, and it's a relatively streamlined process, and it's hard to imagine all the real world possibilities, but likely again, like the existing program, it will mostly be spouses, one would imagine, since a service member here on orders may not be an attorney.
Yes.
Most military positions are not attorney positions. But yes, if you left and came back on new orders, you would go through the process again.
And then the second question, I was just curious, why was there a 5-year limitation in the first place?
I took a look at I looked at the materials from when this was passed in 2019, and I don't recall seeing an explanation for that. Donna, you might have been there.
Yeah, I was. As I recall, one of the things that we tried to do was create some alignment between the several multi-jurisdictional practice programs, the Registered In-House Counsel Program, the Registered Legal Aid Attorney Program, and this program when we were creating it 5 years ago. And so that 5-year limitation is the same as the limitation that's in the Registered Legal Aid Attorney program. This program also had sort of the other limitation, which is why that one may not make sense, that when the spouse leaves, relocates elsewhere, that's when your participation in the program would necessarily terminate. But that's where the 5-year rule came from. It really was about alignment with the other programs.
Yeah, I was just trying to see how that aligned with our views on public protection, but that answers it. Thank you.
Paul?
Yeah, Donna, aren't we talking about eliminating the 5-year requirement for the Registered Legal Aid Attorney Program?
We are. Those rules have been put on hold, but we will be revisiting those, and that is absolutely one of the requirements that we were looking at eliminating.
Okay. So Brady, this prohibition on our collecting fees, I'm not necessarily arguing that we should, although you know, we need every revenue source we can find, and this does have costs. But I didn't see any prohibition in the excerpts from the federal act that you provided to us. So where is that actually written?
Well, Mr. Kramer, it's not actually written, but the legislation spells out, if you submit this application that has the proof of orders, the proof of marriage, and the affidavit, then you are a covered licensee, then you must be permitted to practice. So it does not allow for additional requirements to be imposed.
Okay, I think that may be a conservative read of the statute. I would also suggest, I'm not saying we need to, but that background check could include something akin to a moral character determination. Again, we probably don't need to do it in this case, but thank you for most of my questions in your presentation today. And I apologize for just remembering to send you my marked up version yesterday without a lot of time to go over it. But I had one other question. Should we be verifying that the spouse is actually intending to live in California? Because I assume some military families, you know, if they get moved around a lot, the spouse may, you know, stay at the last post, and it may be a commuter marriage for a while just because they know the service member is going to be moved yet again. And I'm wondering, should we be testing for that so we're not giving somebody a California license to practice it out of their residence in New Jersey, or probably North Carolina is a better example, but what say you?
I'm just taking a quick look at our rule here. You know, I think we could add, because the federal statute does refer to somebody who has relocated, and our definitions in Rule 9.41.1 state that a service member is somebody who's relocated, but we could add to the definition of service member spouse a person who has relocated. I mean, we would need to look at the play with the language, but I think that is something, if you wanted to add that to the resolution, we could add that, and perhaps subject to determining it's permissible under federal law.
I mean, I don't think we mean to empower people who are not residing in California under this approach. So yeah, I would be in favor of trying to add that test to the list of requirements.
Did you want me to pull up the amended resolution, and I can add something for that?
I'm working on
It
it.
sounds like,
Donna's working on that.
Are you in there?
and it sounds like we're at that point where there are no more questions, so.
Yeah,
I have questions, Chair.
go ahead.
Oh, yeah, thank you. Thank you for your presentation. I actually was here in 2019 when we passed this, so I remember some of the alignment that we were trying to uphold. Do you have data on how many individuals have participated in this program?
There are nine currently.
Over time?
I don't have that data, although I don't have any reason to believe it would be much different than around nine at any given time.
Yeah, it was 2 or 3 for the longest time at the beginning.
That's very marginal. But what is the process like? What has it been like? Is it a 3 to 4 month like processing, or are you able to get in and out the program pretty quickly?
So, and I will defer to Donna. In our investigation, and we understand with this, we understand, first of all, with the temporary license provision that since that full moral character is removed, in general, we will be able to do these new ones within 30 days.
Okay.
And I would assume the current program allows practice while the moral character is pending. So I would imagine that that happens pretty quickly. The approval pending moral character, and moral character takes as long as moral character.
And then-
generally takes many months.
So this rule is valid as long as the member is an active duty or reserve or disabled? What is the criteria when it comes to that?
So the criteria it comes from the federal statute, which I believe refers to part of the uniformed services, and it defines that as the branches of the military. It also refers to having to relocate under military orders. So it doesn't, I believe the federal statute doesn't differentiate between active and inactive reserve, but my understanding is that in general, a reserve officer would not be ordered to relocate their residence. That's typically something that happens to active duty members.
Mm-hmm. Okay. Okay, all my questions, thank you.
Okay. Were there any other questions? Donna, are we ready with the resolution?
And
Yes.
Donna, were you working on the link that I shared?
Nope. No, Devin, if you can show the resolutions, it's the alternate resolutions under item 4.8.
Sure.
And check me on number 3.
Oh, make it bigger, not smaller, please. That's better.
And Donna, I'd added to the link my own number 3, which was removing service member attorney from the exception for transfer to unaccompanied remote assignment with no changes authorized. I can teams that to you if you'd like.
For registered, if you can do that, for registered service member attorneys, remove.
This was
Remove registered service member attorney from exception for transfer to unaccompanied/remote assignment with no dependents authorized. So this was the point I was talking about where I made a drafting error in changing the old program to the new program.
Remove registered service member attorneys from exception.
For transfer to unaccompanied/remote assignment with no dependents authorized.
Paul, does this encompass your thoughts?
Yeah, I think so. And I'm happy to leave it to them to wordsmith the exact language on its way to the Board of Trustees.
Okay.
Where did my 3 to go? We'll get it back.
Stand by, please.
Quick clarification for you, Paul. So is your desire that they live in California with their spouse at the time, with their military spouse?
Yeah, if the spouse gets, assigned, let's say they're at whatever that training center is in North Carolina. Camp Lejeune. And the service member gets sent out here, but the spouse is maybe has a law practice back there or whatever. And they're not planning on, and the service member is expecting that it's not going to be that long, or maybe they're going to be sent to Japan next. And so the spouse decides, well, I'm not going to go on that adventure. I'm going to stay at home with the kids in North Carolina. And I see no reason that they should get a California license by virtue of the fact that their service member spouse is currently living in California.
Okay. Your concern was that they may operate remotely as opposed to having a location in person here, right?
Right.
Okay.
Yeah.
Thank you.
All right. Are there any further comments or questions or discussion by members of the committee? If not, Devin, well, first of all, we need a motion, right?
I'll do that.
All right. Moved by Paul Kramer. Is
This
there a
is
second?
Michael. I'll second that.
Michael Cow, Dr. Cow seconds. Devin, could you call the roll?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Misiwala, not present, Joshua Montgomery, not present, Bethany Peak, not present, Vince Reyes,
Yes.
Judge Reyna, not present, Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan, with 11 yeses and 0 nos, the motion passes.
Quick note, just want to thank Mr. Kaplan or Kramer on their support for this and for staff support. Thank you.
Okay. Yeah. Thank you, Brady. Great presentation. All right, moving on to item 4.4. Is this Natalie? Natalie Leonard?
It is. I think she just needs to be promoted.
Okay.
Natalie's been promoted.
Deservedly so.
Okay, Paul, would you like me to begin?
Yeah, go ahead. You can do all of the ed standards today.
Okay, thank you. Okay, so thank you, everyone. My name is Natalie Leonard. I'm a principal program analyst in the Office of Admissions, working with educational standards. We have 3 items on the business portion of the agenda today. The first involves the colleges of law and accredited law school with campuses in Santa Barbara and Ventura, as well as a hybrid JD program. The subject of the motion is the hybrid JD program and a request to move the residency portion of that program from the Santa Barbara and Ventura campuses to Pasadena, California, to Pacific Oaks College. The reason for this change, according to the school, is that the hybrid program is continuing to grow and it has a unique posture versus the others, and they're outgrowing their space. Despite having 2 campuses, the capacity normally is 55 students at each of these campuses, and they have been repurposing other classrooms for this residency portion. Most of the hybrid program takes place remotely, 13 times per year. All 4 cohorts from all 4 years come to campus on a weekend period. They don't access other services or meet with other students, but they bond between themselves and they have an opportunity to meet faculty. The advantage of choosing this space is that Pacific Oaks College is a part of the Community Solution, a consortium of which the Colleges of Law is also a member. Being a part of this consortium allows them to share administrative services, so financial services, IT services, things like that will be very familiar across the campus. So when these hybrid students are attending remotely or when they come into campus, there should be no technical problems at all. Moving to the Pasadena area while retaining the Heritage Santa Barbara and Ventura campuses also allows the school to expand the opportunity that it can provide to citizens of California. The school has been very careful to ensure that this change does not impact the current students that are studying. For most are very excited. Most will find that their travel for the residency will decrease. For those that will have more challenges, they've been given the opportunity to transfer to the regular program, or the campus is also fundraising for scholarship opportunities to assist them with additional costs of commute. So they've been very careful in this regard, and that's been a part of the procedure from the beginning. It was not something that the State Bar needed to initiate or encourage. So that was very nice to see. So that's what I have to share at this point. Paul, is there anything else you'd like to share before we see if the school would like to add public comment?
No, I'm good, thanks.
Okay, and Devin, today I cannot see the participants, but can you let me know if we see any hands from the school?
There are no currently hands raised.
Okay, and as a reminder, the school is not required to make public comment as part of the motion. Okay, thank you. Are there any questions or is there any discussion?
There appear to be none. Natalie, would you like to take all three items or take each item individually for votes?
I would prefer to take them individually just because of the nature, but thank you for that option.
Okay, well, here we go.
I'll make the motion.
All right, is there a second?
Second, this is Vince.
All right, Vince Reyes is seconding the motion. Paul Kramer made the motion. Devin, is there any further discussion? Seeing none, Devin, can you take the roll, please?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy-Walla, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 11 yeses and 0 nos, the motion passes.
Okay, thank you. Moving on to 4.5, Natalie.
Thank you. So the next item involves the American Institute of Law. This is a registered unaccredited correspondence school headquartered in Torrance, California. So the subject here is a non-standard inspection. This school was inspected over 2021 and 2022, and the committee at that time decided to renew the school's registration for a shortened period of time to allow the school an opportunity to self-correct 16 items that were noticed at that time that were considered to be very serious. Therefore, the 5-year extension was not extended. During that time period, we discovered in this most recent inspection that the school did not correct 6 of those, and 8 additional serious instances were noted. These range from the area of unclear communication that is not forthright, issues with clarification of the standards that are needed, overrepresentation of the resources that are available at the school, and issues with the ability of students to persist. This school has been in business since 2015, and the deans operating the school had service at 2 prior schools, and they have enrolled about 300 students in the first-year program starting. Despite this, the results have created 6 licensed attorneys, 2 more just passing in the most recent February 2025 bar exam.
Staff and the inspection team were very concerned about the level of response and collaboration from the school in response to the shortened period of time, and present two options to the committee to consider. Chair Yokelson, this is the reason that I suggested we do separate motions for each of these three items. Staff represents that we believe that one of two options may be appropriate. The first is further decreasing the length of time before the next inspection and having an inspection in spring 2026. So less than a 1-year period, but that time is chosen so that the school can represent that prior to the next school year, everything is in order and fully compliant. In response to that option, we were concerned to see that the school indicated they believe they can achieve substantial compliance, but did not represent that they can receive full compliance by that point. As a result, a second option is proposed that would allow for a compliance inquiry to begin, and the first step of a compliance inquiry would be a warning letter. In conversation with Chair and Vice Chair Vince Reyes and Paul Kramer, they asked if there was a possibility to initiate the warning process immediately, if this would be the way that the committee would go, and therefore a third alternative motion not presented on the agenda, but that can be shared here, could be provided to you. So the choices before you are to consider a 1-year renewal, less than 1 year, with the next inspection in spring 2026, or alternatively to begin the process of a compliance inquiry with a warning letter. So with that, Paul, do you have anything to add before we turn it to the school for public comment? I do believe they plan to make a comment.
No, I'm curious to hear their thoughts about those options.
Okay, and prior to turning it over to the deans, I will indicate that unfortunately the dean serving at the school this past year has passed, and so we send our condolences to the law school family. We did make accommodations in terms of timing to allow the school to properly care for and grieve the dean. And Devin, would you please recognize Mel Morrison, part of the leadership team of American Institute of Law, for up to 5 minutes of public comment?
They've been unmuted.
Good morning, committee members. Can you hear me?
Yes. We can.
Yes.
My name is Mel Morrison, speaking on behalf of American Institute of Law. I wish to thank the Committee of Bar Examiners for its time and commitments to its critical mission of oversight. To the Chair, Alex Chan, Vice Chair, Alan Yokelson, and the rest of the dedicated committee members, I am delighted to have the opportunity to share some brief comments. It is truly a privilege to have been provided support from Natalie Leonard and Bethany Peak during the inspection process. They have been both thorough and kind. Last summer, we informed the State Bar that my good friend, pardon me if I get a little emotional, Edward Green was extremely ill and was on medical leave. During his hospitalization, we continued to pray for him in the hope that he would soon recover. After his long battle, we learned that Ed Green had succumbed to his illnesses and had passed away. This came as a complete surprise to the entire staff because he was in charge of responding to the inspection in 2021 and 2022. It was particularly hurtful to me as he was a good friend of mine that I had known for 19 years. Ed and I met when I had joined Abraham Lincoln University in 2006. Over the next few years, we realized that we had both unique talents and a passion to educate. In the winter of 2009, Ed and I began to discuss the concept of offering a truly unique online live interactive program to those students who might not otherwise be able to attend law school due to finances and time constraints. It was then that we both agreed on the name of the school would be called American Institute of Law. Actually, this happened at McDonald's. We were eating dinner. And that would provide a traditional law program for the 21st century that is affordable, accessible, flexible, and convenient. We knew that this would take several years to plan and execute. In the summer of 2010, we joined American Heritage University, located in San Bernardino, California. We were invited to attend their first inspection, headed by George Leal. After the inspection, I asked George Leal to give Ed and I 1 year to help AHU greatly improve its program. During the year, Ed and I helped the school to substantially, if not completely, comply with all guidelines, and their next inspection was nearly perfect. As a result, AHU was granted a 5-year renewal. George would always compliment Ed and I as having changed AHU into becoming a flagship of how a law school should operate. After 5 years of preparation and planning, American Institute of Law was incorporated on May 7, 2015. I began to design the school's seal, catalog, and website. Ed Green and I designed the academic component of our program. We began using Populi as our learning management system and purchased Mega Meeting Enterprise Edition as our live interactive lecture interface. We enrolled our first student on February 2nd, 2016. I have also been working closely with Dean Michael Dowd since 2008. He has been an outstanding professor and advisor. Mike Dowd and I acknowledge AIL's shortcomings, and we are certain we will complete each area of the inspection team's recommendation to full compliance and use these improvements to seek perfection as we become a flagship school. Pardon me. Once again, we greatly appreciate Natalie Leonard and her team's recommendation that the next inspection be administered in the spring of 2026, with our commitment to keep the State Bar aware of the improvements which are already being implemented. Our changes will show evidence of completion and timeliness. We will also include evidence of all changes in annual reports as well as periodic emails. We also wish to respectfully request that the Committee of Bar Examiners and the inspection team consider allowing the next inspection to be administered in the fall of 2026. This will allow a bit more time for us to continue to increase our pass rates, lower our attrition, and add more technology to our system, and possibly add some elective courses prior to the inspection. It is our future intention to seek accreditation. I wish to thank all the committee members and the inspection team very kindly for your consideration. I'm sorry about the emotion here.
Thank you, sir.
Thank you, Dean Morrison. Listening to the remarks, I will say that a couple of points did stand out to staff that were mentioned also in these remarks. Dean Morrison discusses that the school is a live interactive program, and it is true that students may attend the program live and in an interactive fashion, but it is not a requirement. And one of the issues that the team observed is that students may come expecting a classroom and an interactive experience delivered via distance, but generally a few students take advantage of this issue. With respect to student disclosures, which are the bedrock of information so that students can make an informed decision, we have undergone many rounds of changes, and issues still remain regarding those disclosures. And so without having correct and complete disclosures online, students may enroll under a misimpression. At this time, the school has created correct disclosures on one version of its website, but also maintains another version despite a representation to take that website down, and that contains incorrect disclosures. With respect to the attrition and the ability to have a reasonable opportunity to license upon returning for the most recent inspection, the school could identify only one reason: financial counseling as the need for that. They have not created financial counseling. And so it is of great concern that despite a period of continued scrutiny, a plan was not created. So I think those might be helpful to the discussion. Are there any questions or comments?
Do we know how much the depth of Dean Green contributed to this?
I understand that Dean Green and Dean Morrison have been business partners for many years. And I understand that that Dean Morrison must feel significant grief as to that indication. The school's been aware during 2022, 2023, and the first half of 2024, prior to the change in Dean Green's health, and has had a significant period of time since the inspection with experienced leadership of Mel Morrison and Mike Dowd, the current dean. Therefore, I don't believe that while the impact and the loss of Dean Green will be something that will be considered and continue to be felt by the school, I don't believe that it was significant enough to avoid further compliance issues at this time.
What happens if the committee decides to issue the letter of compliance? We'll go down that route.
At that point, the warning will be issued. The committee has the ability to determine the amount of days that the school can respond. Generally, in the past, it's been 15 to 30 days. If the response is not satisfactory, a formal notice of noncompliance will be issued. There will be a further inspection right away, as well as potentially a hearing if the school indicates that they would like to have one, and probation may be imposed or withdrawal of administration may be imposed.
Yeah, Alan, it's a long process for registered schools, and it's one of the things that we intend to reduce the length of and the number of steps when we do get around to revising the registered school rules. So, well, it's unfortunate. In my opinion, this school is at the stage where we need to start the process, not just simply say we're going to come back and look again in next year, but to say you guys need to get these things fixed pretty quickly. I'm not saying we give them a 15-day deadline. I'm thinking something on the order of a minimum of 90 days, but that gets the process started. So if they're ultimately not able to come into compliance, we can resolve it a little bit quicker than if we wait until next year to start the process. So I'm in favor of I guess it's probably the third option that Natalie spoke to, because that has language that's a little bit cleaned up from the second option that's in the staff report.
Are there other committee
I hope
members?
that they can turn it around,
I did have
but we need to apply
apologies. I did have the one question, if there was an explanation provided as to why there are two different websites. And then just a comment, leaning towards, Paul's comments about having, this letter sent out to them. But if we do that, to provide them with, maybe the longer, period of time, because there was that death in the administration.
Is that Ashley? I can't.
I believe it's Julianne.
Oh, that was Julian. I'm sorry, Julian. I couldn't see you there.
Yes, so the second website was indicated by the school to be a user area that was identified as malware and inappropriate to be shown, but it continues to be shown, and it's been a period of weeks. It's not uncommon to find a minor issue here or there with a disclosure, and they are generally fixed, sometimes within hours and certainly within a week. And here we've been working with the school for many months, and the shadow website, it's been at least a period of multiple weeks.
Are there any other questions or comments? Paul, do you want to make a motion?
Natalie, can you put up the third version?
Yes, we will put that up, and it's very similar to the second motion. The primary difference is that it allows for the staff to issue a warning to the school, and the warning letter will reference the inspection report. The committee would adopt the inspection report in full, and it would authorize staff to immediately transmit the warning letter. As part of submitting the warning letter, the committee has full discretion as to the number of days in which it would like the school to respond. So you see a blank in there in order to insert the number of days.
Well, let's insert 90. That's what Paul was talking about.
At least I could go for more if somebody wants to argue that, but
120?
that's 4 months. That seems reasonable. I mean, more than reasonable. And in the first line of that paragraph, could we say warning letter, just to be clear?
Yes.
Okay. Paul, is this your motion?
Yes.
All right, is there a second?
Yeah, I'll second the motion. This is Vince.
Is there any further discussion? Bearing in mind that there are other options if this is voted down. All right, seeing none, Devin, can you call the roll, please?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Macy Walla, not present, Joshua Montgomery, not present, Bethany Peak, not present, Vince Reyes,
Yes.
Judge Reyna, not present, Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 11 yeses and 0 nos, the motion passes.
All right, thank you. And then finally, item 4.7.
Thank you. This is the periodic inspection of the California Desert Trial Academy. This is an unaccredited registered fixed facility law school located in Indio, California. This school was inspected on a typical periodic basis. A number of compliance issues were noted, and the school has worked to address them. They are nearly all addressed in full. Several of the items involve demonstrating implementation of the programs and policies with this upcoming school year, including their interactive Saturday program. They've always had this program, but they've made the terms more clear and added more academic rigor to that program. Staff would like to thank the school for their collaboration and their cooperation in addressing these communication and compliance concerns. And the staff recommendation is a renewal with a standard 5-year plan to inspect in 2029. Paul, anything to add before we determine if the school would like to make a comment?
Nope.
Okay, and I don't believe they were planning to do so, and I don't see any hands raised, so I believe we can proceed to the discussion. And as a requirement, the schools are not do not need to appear to make a public comment, so please do not draw an inference if they chose not to.
Thank you. Why don't we put the recommendation up there and see if there's any discussion? Okay. Do any of the committee members have any questions or comments?
I had a question about the last part. This is Julianne. When it's saying they're directed to file an addendum, is there any deadline for that addendum that they need to file?
Yes, so this refers to the 2025 annual compliance report, which has a deadline of November 15. And if you'd like, we can place that in the motion for clarity.
That's fine. Go ahead, Natalie.
Yeah, Natalie, maybe just say with the 2025 annual compliance report, and that takes care of the deadline.
Thank you. Instead of to, we'll change it to with. It's
Yeah, the schools are certainly aware of that deadline.
Are there any other questions or comments? Can I have a motion?
Yeah, I'll move the motion.
Vince Reyes moves. Is there a second?
This is Mike, I'll second that.
Dr. Cows seconds. Any further discussion? Seeing none. Devin, can you call the roll, please?
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn,
Yes.
Justice Masiwala, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan. With 11 yeses and 0 nos, the motion passes.
Thank you. This concludes the educational standards business portion.
Thank you very much, Natalie. And thank you, Ed Standards and Paul, for your work. At this point, or at this time, the committee is going to go into closed session for 2 items. We will return from closed session around 1 o'clock for members of the public. It will be back around 1 o'clock, and we'll start off with agenda item 4.1. So thank you very much, everybody. And at this point, we're going to end the open session and go into closed. Thank you.
Members should see an invitation from me from earlier today for closed.
Thanks, everybody. See you in closed.
sorry. No, it's so fine. It's convenient because I'm, right there. So I can put this on.
The LA office should be joining shortly. They're just swapping out the mics.
Thank you. Welcome back. It's 1 o'clock and we're back in open session. Do we need to take roll again?
We do.
Evan, please call the roll.
Dr. Bolton? Dr. Cow? Alex Chan? Kareem Gangora? Kareem Gangora?
Present.
Larry Kaplan?
Here.
Paul Kramer?
Here.
Alex Lawrence?
Here.
Esther Lynn?
Here.
Justice Misiwala? Joshua Montgomery? Bethany Peak? Vince Reyes?
Here.
Judge Reyna? Ashley Silva Guzman?
Here.
Julianne Smith?
Here.
Alan Yokelson?
Here.
We have a quorum.
Next on the agenda is discussion and action mode and, and method of delivery for the content of the California bar examination after July 2025, including the consideration of recommendations related to the Supreme Court order to develop a California-specific bar examination. Donna Herskovitz of the Office of Admissions, Chief of Programs, will present this item. And this is 4.1, if I didn't mention that. Donna?
Thank you, Mr. Chair.
Vice Chair.
Mr. Chair for today. I'm going to share my screen and we'll get started. Okay. So I spent a lot of time thinking about how best to start this discussion today. And part of me just wanted to jump right in, but I think for the benefit of the committee members and the benefit of the public, I want to just do a little level setting of kind of why we're here and why we are faced with having to make these decisions or start these conversations anyway. So obviously the committee members are well versed in things that have gone on with the February bar exam, but just to remind everybody, on May the 5th, we released results, and the next day we released, for those who were unsuccessful on the exam, we released the results letters and access to, it gave individuals access to their written answers. As a result of that, we discovered that there were some issues. We identified three applicants who had each of them having one essay that was not theirs, that was assigned to them. We went back and we reassigned the right essay to them and looked if that affected the outcome on their exams. We also then subsequently discovered that there were some issues with those who participated in the March 18 and 19 retake of the exam, which was held in response to obviously a lot of the concerns that were experienced on the exam. And so for those who had less than 2/3 of written responses or multiple choice responses, we permitted them to retake that portion of the exam that they did not have sufficient answers on. And it turned out that in doing so, when we were doing the grading, for some applicants, we switched essays 4 and 5, and so despite the fact that they took the essays that we told them to, nonetheless, there were a small number of people whom we gave a 0 because we recorded them as not having taken one of the essays that they needed to, though they had. And so we went through all of those to make sure that everybody who was assigned a 0, in fact, had their exam properly graded. If the grading of that essay, which had been deemed a 0 previously, put them into second read, then we put them through the second read process as well. After that, we did identify an issue with the notes field. Specifically for the performance test, we had identified that there were 400 plus applicants, about 200 of whom, 400 plus applicants for whom we exported only a partial set of the notes and gave that partial set to the graders. For 200 or so of those 400 test takers, there was a mathematical possibility that a change in their score on their performance test could result in them passing. And so we regraded all of those 200. We gave the graders, the original grader who read the exam, we gave them the notes, the complete set of notes, asked them to regrade the exam. They did so. And again, if this led to somebody needing a second read, then we went through the second read process. Overall, with those issues, we ended up with 13 additional applicants who had previously been told that they were unsuccessful on the exam passing. Subsequent to that, as a result of the action by the committee, we looked at those who had both a first and second read, and instead of averaging the scores for first and second read for each question, we awarded the highest of the first and the second read score for each question. That resulted in an additional 230 applicants passing. And then, at the recommendation of this committee and the approval by the Supreme Court, we said for every applicant who was unsuccessful on the exam, what would happen if we imputed a score for the performance test? Would that be higher than the score that they were awarded? If it was higher than the score that they were awarded based on grading of what they had written, then we counted that higher imputed performance test score. That resulted in an additional 80 applicants passing the exam. We do have, we are launching, as you know, a privileged independent third-party review. We're contracting with HUMRO, the Human Resources Research Organization, to do 2 reviews. One is for everyone who failed the exam, to look for any scoring irregularities. We know the things that we have found so far, and they're going to double and triple check to make sure that we have fixed all of those problems. They are also going to, using their expertise, identify other problems as well as problems that have arisen based on information contained in request for reconsideration that we have received from test takers. They are not addressing technological issues that people had. They are not recommending we're going to add X number of points because this individual lost time on their essay because the proctor was trying to resolve something and the proctor didn't stop time. They're looking at the scoring issues. They're going to look top to bottom how we score and identify if there are any scoring issues or irregularities based on the decision rules that we have for scoring and what we have said that we would do. The second part of the review is for applicants who had testing accommodations. You all have heard from some applicants who have said that their testing accommodations, which were approved by the state bar, were denied on the exam. And so the consultants will be looking at those issues. They'll be looking at videos. They are providing opportunities for the applicants to be interviewed by them. We've asked them to prioritize any review of any applicant who has registered for the July 25 exam. But it is going to be with the goal of getting anybody who's sitting for July, having that review completed before the exam. For others, having that review completed after the July exam. But the scoring irregularities is all going to also be done before the exam. So that's what happened in February. Again, I know you're all aware of that. I just wanted to set the stage there. So looking forward to the July exam, we know a number of things. We know that we have been directed to return to an in-person exam and to return to the NCBE's MBE, the multi-state bar exam, for the multiple choice portion of the exam. Staff have, frankly, quicker than I thought they would be able to do. I've been very pleased with how staff have been able to get us ready for the exam. They were able to contract with the test centers in order to provide test centers in the locations in the general locations where we typically have test centers across the state. We have received almost 9,800 applications to sit for the bar exam. We are still in the process of ensuring that everybody meets the eligibility, that we've got the certificates of good standing and the law school transcripts or certifications from the law school. But that is the number of people who've applied. You can see here the vast majority are for the 2-day general bar exam, 550 or so for the 1-day attorney exam. We also have received about 1,300 applications from those requesting testing accommodations. That's slightly higher percentage than we had anticipated based on prior history. We are processing those applications, and we have onboarded. You can see we fully onboarded nearly 1,100 proctors. We've estimated about a little over 1,300 proctors that are needed. We have the others in the pipeline. We had commitments from about 925 proctors that we've used in the past that were willing and available to come back. And then through other sources that staff reached out to, we have received applications from about 700 new proctors from new sources. We may still need to bring in some temps for based on location, because if we don't have enough proctors in the particular locations that we need them, there may be a small number of temp staff that we need to bring on as well. But staff is feeling very good that we are well situated to have the full number of proctors that we need in time for the exam. And so that's where we are moving forward for the July exam. Questions before I move on to planning ahead?
Larry? Yeah, are you going to talk about the financial impacts of all this?
Yes.
Okay.
I had a quick question. I think we might have talked about this, but how is that's an increase from our usual July test amount, is it? And do you know how much approximately?
It is an increase. I'm not sure the exact amount. I mean, because how many apply to sit for the exam versus how many actually sit for the exam, there is always a drop off in that number. We anticipated, we projected 10,000 applicants. And we, as you saw, we now have, we have just about 9,800. So our projection was pretty close. Based on an item that's on the committee's consent calendar today, which will then proceed to the board, which will give some flexibility for those who had signed up for, withdrew from the February exam, to apply the fee waiver, to withdraw now and apply the fee waiver. there's a consent item that provides some additional flexibility. We imagine that when that is adopted by the committee and the board, that will also lead to some more people withdrawing from the exam. But yeah, I think we're typically at about 9,200 maybe, and now we're at about 9,800 in terms of applications at this time.
Thanks.
So planning ahead. So we know what we're doing in July, and that's the exam that we've always done. The committee needs to start thinking about what is it that we are going to do going forward for February 26, July 26, and future. And there are a couple of inputs to that decision making, conversation considerations, as we've called them here, that I want to go through. So first, obviously, is that we for this past exam we transitioned to California Developed Multiple Choice Questions. We are, as I said, going back to the MBE for July. And as you'll hear more in a minute, we will be staying with the MBE in all likelihood for at least 2 more years, depending on what the committee and the board choose to recommend sort of beyond that. But the reason for the transition to these to the California Developed Multiple Choice Questions in the immediate term was to enable remote or small test center based testing as opposed to the convention centers and hotels that we typically do, because surveys tell us that applicants prefer remote or a smaller test center based testing. It's closer to home. They don't have the additional expenses of having to travel to a hotel, stay at a hotel, buy food, etc. For some, it reduces anxiety to be in a familiar setting. Don't have the commute traffic and the nervousness that brings, and so those are among the reasons that applicants have told us in surveys that they prefer the remote test or test center based testing. Also, it is more cost efficient as compared to an in-person modality. Doing a 2-day or more, if you have extended days, in-person exam at convention centers and hotels is the most costly way to put on an exam. As you see here, it was originally expected that we would save about $4 million annually due to a transition to remote testing. The actual cost savings were reduced in part because of the need to add some significant in-person testing space when we did the February exam. But that's sort of right. That's first thing to just think about is we have a contract with Kaplan Exam Services to develop these multiple choice questions. In a couple of more slides, I'll go over some of the costs of that contract. When it comes to the future bar exam, right? So, and it's hard to think about these, but we've got sort of 2 things. One is the quote unquote current exam, which uses the Kaplan multiple choice questions and the essay and performance test questions that we've always done. Then there's the future exam, the new exam that the Supreme Court in October 2024 directed, pursuant to the recommendations of the Blue Ribbon Commission on the Future of the Bar Exam, directed that we not go to the NCBE's next gen uniform bar exam, but rather that we develop a California specific bar exam. And we have anticipated a 5-year development cycle for that exam. So what we would have used Kaplan multiple choice and our own essay questions would have gotten us to that new exam. Again, obviously, I don't need to tell the Committee of Bar Examiners the rollout of the remote exam in February and the multiple choice was poorly executed, lacked transparency, and it impacted trust and credibility. That is part of what brought us back to this conversation today, and what brought us obviously back to the MBE and in-person exams for July, understanding the problems that were experienced during the February 2025 exam. You need to take that into consideration, obviously, in directing what we do in the future. Next, Senate Bill 253. This is the annual bill that sets the licensing fee that the state bar is able to assess to licensed attorneys. It also provides an opportunity every year for the legislature to include governance issues or a variety of other issues that it feels are important, that are necessitated by events that have occurred. And so in this instance, SB 253 takes the statute that indicates that 2-year notice must be provided if the committee is going to make any change to the bar exam that requires substantial modification of the training or preparation to pass the exam. What the legislature has proposed in SB 253 is essentially defining changes that do require that 2-year notice, changes that would meet that requirement of substantial modification of training and preparation, and said that changing the vendor for the multiple choice questions after the July exam from NCBE, that would be constitute a substantial modification, and that would require 2 years notice. Changing the functionality of the testing software or materials, or changing the medium in which the testing materials are provided. That language will be further amended such that the second bullet and the third bullet are going to be changed to 120 days or 4-month notice for the second and third bullet. And I expect to see that will likely happen as part of the committee hearing on that legislation this coming Tuesday, June 24. Based on conversations that we've had with staff in the legislature, I am not anticipating that the legislature, or certainly in the Assembly Judiciary Committee, that there would be movement on the 2-year notification for changing the multiple choice vendor after the July exam from the NCBE. So another thing to think about, and part of the reason that we're doing this also is the Board of Trustees at their May meeting came up with guiding principles and priorities for consideration of how to move forward in the short term and in the long term. And they asked the Committee of Bar Examiners they recommended the Committee of Bar Examiners adopt the same guiding principles and priorities. And so we will be talking about those guiding principles and priorities in just a few moments to see if this committee wants to adopt the same or modify the priorities and principles that the Board of Trustees adopted. And so looking at the future exam, the new exam of the future that was directed by the Supreme Court, we just wanted to give you some understanding of what the basis was for the recommendation. That was a recommendation from the Blue Ribbon Commission on the future of the bar exam, which included 2 members of this committee, Alex Chan and Esther Lin, and was adopted by the Supreme Court. And so in thinking about what to advance, the Blue Ribbon Commission was swayed by the fact that a California Develop exam would allow us to test specific knowledge, skills, and abilities to be an entry-level attorney in California. We did a practice analysis, sometimes called a job analysis. We performed that practice analysis to identify what the knowledge, skills, and abilities, what those KSAs are for entry-level attorneys in California. As a result, the Blue Ribbon Commission recommended 9 topics for the California specific bar exam. The Supreme Court added 3 more. And so there would be 12 topics based on the order of the Supreme Court. But among the things that are unique, that I do not believe are covered in the NCBE's Next Gen, that did rise to the top amongst the top of the list of subject matters that were important for entry-level attorneys in California, was administrative law and procedure and employment law. I think both for the California specific exam as well as the next gen, there is an increased emphasis on the skills and abilities and application of those skills, and a reduced focus on memorization of doctrinal law. So that's sort of how we got to where we were, and why. Why did the Blue Ribbon Commission recommend a California specific exam? The feeling was that decoupling from the National Conference of Bar Examiners would allow for full control of the exam, greater flexibility and innovation in the content of the exam, how we deliver the exam remotely, small test centers, and the frequency and the precise timing of the exam. We could, if we have a large enough question banks, we could offer the exam more than twice a year. We could offer the exam at small test centers with them being delivered over the course of a week, so long as we had sufficient number of forms and questions in order to be able to protect the security and the integrity of the exam. But it could be more of a on demand, if you will, within a 1 week or 2 week span, as opposed to everybody sitting on the exact same day, because there are not test centers in California currently that would support the numbers of people that we have taking the exam. So just getting to some of the budget issues, because as we did say, the in-person exam is the fully in-person exam is more expensive. And so we just wanted to remind everybody that we did recently increase the fees on applicants in order to, and you'll see on the next slide, in order to maintain an in-person exam. We will obviously look for efficiencies in all of admissions operations. We will look for cost savings, but in light of the significant percentage of the admissions budget that the bar exam is, in order to support that more expensive version of the exam, there will have to be future increases to the applicant fees. And I don't mean that far off. There would have to be increases in the near future. Larry, this is the screen you're looking for.
Okay, back to the screen before. What does current mean? What is prior? Larry, can you?
So for those who didn't hear, Mr. Kaplan asked what does it mean to say the current fee versus the prior fee? So the current fee is what is being charged right now for the bar exam. The prior fee was the fee went up in 2023 for the February 2024 bar exam, and so those are the prior fee applies to refers to that. So here's a quick snapshot of the admissions fund, and you'll see the adopted budget versus the revised budget for both revised budget for 25 and the 2026 adopted forecast and the revised forecast that were revised based on the fact that we are going fully in person in July. And the budget assumes in-person administration for all of 26. It assumes that we will be paying the NCBE for use of the MBE in all of 26. And it assumes that we are continuing to pay on the contract that we have with Kaplan. It also builds in additional staff to support an in-person administration. And so you'll see we went from a situation where we had a surplus to a situation where we now are in the red, and by the end of 2026, the admissions fund reserves will be fully depleted and we will be in a negative situation. So something needs to turn around before the end of 2026 in order to continue to support this model. So here are, and I borrowed a lot of these slides from the presentation that was done to the board, for the board in May. And so some of the terminology doesn't take into account the existence of SB 253. And so obviously we'll be continuing to talk more about that. But this just lists some of the decision variables and the costs that are involved, or really the costs that are involved in the different in two different exam modalities, in person versus remote. What the differential is, and that we know that we have been seeing facilities costs go up. We've seen proctor rates increase, additional staffing needed to support in-person, permanently supporting in-person exams. We do have this contract with Kaplan Exam Services. We've identified what is the current cost for the MBE. And so that's what we lay out here on this slide. Audrey, I think maybe this would be a good time for me to stop sharing and for you to talk a little bit about NextGen, and then we can go on to the guiding principles.
Right. When you stop, I can share my screen. Okay, I'm just going to quickly talk about the construction of the NextGen exam as I know it. So the foundational concepts and principles are there on the left: business association, civil procedure, con law, contract law, criminal law, evidence, real property, and torts. And starting with the July 2028 version of the NextGen, family law will be tested. Skills tested: legal research, legal writing, issue spotting and analysis, investigation and evaluation, client counseling and advising, negotiation and dispute resolution, client relationship and management. So jurisdictions have been signing on for a few years, and the first iteration of the NextGen will be delivered in July 2026.
Audrey, can I stop you? So it looks like the skills are remarkably similar to what we're shooting for in our next test, but it's the subjects are a reduced set. Is that a fair?
I can skip ahead. I made a table thinking you would ask me this, but I made a table about the doctrinal topics and skills, trying to highlight for you where there's just some differences in topics from the court order received October 10th, 2024, and what is publicly known about what's being tested on the NextGen. Does that help, Paul? Is it all right if I can go back and then we can come back to kind of this comparison at the end
I
of
think
my...
there's a delay whenever Paul unmutes.
Oh, I can't see him.
I did see his mouth move.
Okay, I can't see him, sorry. Paul?
Yeah, no, I'm good. Go, carry on.
Okay, we can come back to this. Oops. So the design, it's been in development for several years, and initially this kind of percentage breakdown was totally different, but now it's 40% MBE like multiple choice questions. The rest of the test is split between what they're calling integrated question sets, and then what we already know we call performance test and they call performance task. 25% about integrated question sets. So there's like a fact pattern scenario, and then based on that, there are several different kinds of questions that are asked. The fact scenario can have statutes, case law, different documents to read through, and then you might get 2 multiple choice questions and a short answer, or some sort of only short answer, just different questions that come after this fact pattern. Testing doctrinal knowledge, practical skills, some of those skills covered in that slide before. And then about 33%, a third, will be performance tasks. Just like we understand here, there's a file and library, and some of the performance task questions will be like research focused. So there'll be multiple choice questions and short answers that follow that, and maybe one medium length written response, and one sounds like the current version of what we know as the performance test, where it's a longer writing assignment. The
So
exam,
essays have more or less disappeared then.
they don't have the essay questions in this design in the same way that we have on the current California bar exam. In terms of exam administration, so the next gen will be similar to what happens now with the UBE, where that exam is administered and graded by the jurisdiction. The NCBE will provide the technology platform for grading. The next gen is 1.5 days. So day 1 is split like a morning, afternoon, 3-hour sessions. Day 2 is 1 3-hour session. And then those jurisdictions that have, like New York has a New York component, they would do that the other half of the day on day 2. The exam will be taken on examinees' own laptops, in person at jurisdiction-run proctored testing locations, using a secure online assessment platform to present the questions and collect the responses. That's similar to what we do with ExamSoft in person, but that vendor will not be ExamSoft for the next gen. The platform will support assistive technologies for those with accommodations and custom formats. There is no publicly available information on cost. Any questions here? And then again, if this is helpful, I can go back to this chart from the court order and from what we all know publicly about next gen, kind of which unique subjects are on the California proposed court order from October 24, and then what's different in the NCBE next gen, where they're testing business associations, and that is not one of the 12 topics. Also, I did want to note that in that court order from October 10th, 2024, the court was asking that in the test design, it's designed such that it could allow independent scorable parts. So the test is not altogether the way we have the essays, performance test, and the multiple choice, and you can't really break them apart, but that you consider in the design that parts of the exam can be independent, scorable on their own, and then applicant can be allowed to retake only where they were unsuccessful. And I showed you the current design. It's going to be administered over the same dates in February and July for the next gen, and it will not have breakout kind of sections that you can take independently and score independently. Those are some of the differences.
Is there talk of the next gen eventually allowing remote taking?
I have heard no talk of that, no.
Yeah,
Audrey. Yes.
Audrey, yeah, when I attended the national conference nationwide meeting last month, and there was no talk about remote testing. One of the other concerns I had, because the results are portable, it facilitates reciprocity, which currently our legislation doesn't allow for it anyway. But also one of my concerns was calibration between the jurisdictions. So somebody passes in state A, they can take that result to California, but if state A grades on a different scale or grades easier, for example, it would seem to be a pathway in the California. So that's one of the disadvantages that I saw.
Isn't it the case, though, that each state sets their own cut score, but it's all scaled?
That is true. That is true. But if somebody passes in state A, according to state A's cut score, you're saying, Paul, that they would have to meet California's cut score? Is that what you're saying?
Yeah, so if they fall somewhere in between, sorry, Charlie.
And that's how we have it with the NPR. The MPRE currently, we have a higher score for passing on the MPRE than a lot of other states. So assumedly we'd be, even though it would be the same exam, we could have a higher cut score.
And I believe, Audrey, you're more familiar than I with the components of the NCBE, but the next gen, but I believe although the grading and the scoring would happen locally in each jurisdiction, that, is this correct, that that the national conference would be providing grading rubrics and would do a training for the grading of the exams?
That's my understanding, and they have, I think they've already completed like a standard study on what will be tested in July 26th. So I believe that jurisdictions would have all that information.
Is there something akin to our calibration?
I don't know the answer.
Yeah, I was trying to explore that, and I just couldn't get a clear answer at that time.
I don't think that there is national calibration. I think we would continue to do our own calibration using the scoring rubrics that they provide. Again, that is my understanding that they're providing scoring rubrics. But I do not believe that there is a national calibration.
Kareem, you had a question?
I did. I kind of wanted to get some more feedback. Obviously, the court order is a little bit more expansive, inclusive of additional topics, skills being tested, subjects, and so are we setting ourselves up to do something that we might be over-promising and under-delivering?
In what sense?
And the idea that the NCBE has these focus points and then they're phasing in the family law, while the expectation for the court order is that we're inclusive of all these different criteria. Like we're setting the bar pretty high. I'm just saying, at what point are you going to phase in things as opposed to do a catch-all approach?
Yeah, and that is something certainly that as the development gets underway, which it hasn't yet.
Okay.
And this committee will recall that you had a conversation about creating a steering committee and a policy advisory committee. That was put on hold when everything started happening with the February exam.
Okay.
So we haven't started those processes yet, but certainly as those are developed, if it becomes apparent that that we can roll out everything but one of the
Okay.
subjects, right, or two of the subjects, then we would
That's within our
petition
purview.
we'd petition the Supreme
Supreme Court,
Court
okay.
and explain, what we need in order to pull off the exam
Okay.
the best way possible.
Because I'm assuming you're going to need different subject matter experts, additional time of staff to develop. I mean, it's obviously you could look at the chart, and thank you, Audrey, for displaying it this way, because it's a lot more polarizing and just shows that we're definitely trying to achieve a certain goal, but I feel like it'll be more expensive to go this route. Just looking at it objectively.
Well, and also to Kareem's point, if the court wanted us to test on certain subjects that are not in the next gen, if we were to go that route, we could follow the New York model and just have an additional half day, California.
And we'll get there, and that's part of the reason that we're presenting on this too, is that's part of the conversation that Mr. Kramer in particular wanted to make sure that the committee had the opportunity to say, we know that the court made this order, and for very good reasons made this order in October. Mr. Kramer said, other things have happened since then, and wanted the committee to have the opportunity to discuss whether you thought it was appropriate to request that the court rethink that, or confirm that, no, that is, whether you wanted to confirm, yes, that is the way that we should move forward. We should continue to move forward with the California exam. So we will get there in just a few moments. Audrey, that was the end of your slides, I think?
Correct.
So I will start sharing again. And so I'm going to be asking you to start to think about guiding principles and priorities that you want to use in making recommendations for the shorter term administration and content development for the exam, and then the longer term, i.e. the new exam, as well. But I think it's important to start looking at these. These are the priorities and principles that the Board of Trustees adopted and requested that the committee to consider adopting as well. I've broken it up into 2 screens, so it didn't get super tiny for you. So this is half of them. And so maybe it'll make sense to read them. Doing it right is more important than doing it fast or doing it cheap. Another guiding principle is delivering a reliable and predictable exam, minimizing risk. And the ways the board talked about minimizing risk is if changes are made, phase the rollout. Also discussed as don't do 2 things at once, as was done with February. Phase the rollout, move with caution. And keep that one in mind because we'll get to sort of the inverse of that in a moment. If changes are made, use proven technology and ensure that there is appropriate testing to minimize the risk. Deliver an exam, again, new guiding principle, new priority, delivering an exam that appropriately assesses for minimum competence to practice law in California. The exam must be accessible, affordable, fair, and equitable for test takers. That is a priority that comes from the Blue Ribbon Commission and that was adopted by the Supreme Court in its October 2024 order. Lessons from the February 2025 exam must be learned before moving back to a remote online exam. Consider developing an exam that can be delivered on a more frequent basis than twice a year. Caution, remember we talked about caution in a second ago. Caution cannot trump innovation. Consider both remote and in-person options. Improve work with stakeholders to ensure greater transparency, ensure that stakeholder perspectives are being sought out and are considered. Partner with law schools to test exam administration platforms and approaches. Many of the law schools do remote tests. Having them help with helping us learn about the software they use, as well as, if we can use the law school space and use law schools to help us test platforms. Improved work with stakeholders includes a strong collaboration between the board, the Committee of Bar Examiners, and the Supreme Court, and ensure also that we engage with legislative partners. And then the final guiding principle was we can't rely on business as usual to drive the approach. So there's a lot packed in there. I don't know if this, I think this is the time, because I think I would recommend ultimately that the committee adopt a set of guiding principles and priorities, whether it's this or an alternative version. That is up to the committee. But I think this is the time to nail down the committee's guiding principles and then move on to, now that we have those, let's talk about what we're recommending for short-term and long-term administration and development. So should I go back to the first slide of these two? And I see that Mr. Kramer had his hand raised.
Paul?
Yeah, my question was about the next slide. What does the last item mean?
As I recall the discussion, the last item is about thinking about different ways to do things. It's about it could be about using test centers. It could, right, sort of different ways to put on the exam. And I think as I'm thinking about it, as I'm saying this, it was also just like a broader discussion. I think summing up a lot of these bullets, right? The business as usual approach, we just, if we made a decision and forged ahead, it's make sure you're engaging stakeholders. I think it really is sort of looking at the process or the administration that we have used in the past and not being tied just to exactly how it's been done, but also the process that we've used to decide in the past and make sure that we are more broad in our approach.
It's a variation of caution cannot trump innovation,
Mm-hmm.
although business as usual is quite often just inertia. It's not motivated by caution or anything else but inertia. Okay, I'll have more comments, but I'll let others talk.
Larry? Yeah, Here we go. I just want to throw out there, we don't hear about the money stuff that much. Okay, we're all hung up on the details, the questions, the this, the process, blah, blah, blah. But, you know, let's get real, okay? Money talks, BS walks. If the money ain't there, we're out of business. And the people of California are not being served. And somebody's gonna come in and tell us how to do our jobs. So I think we need to put, with all due respect to the Supreme Court, I don't think they really think about it much either. Okay, they are literally, they're up there and they, you know, and they do their thing. I don't think they ever think about money. The way that somebody like the governor has to think about money, or the legislature has to think about money, or people who have businesses, or the agency heads, or the people running this department. So I would like us to put some time and energy into how are we going to pay for this? How are we going to pay for this and maintain the integrity of the process and keep the exam accessible, affordable, fair, and equitable? How are we going to do that?
That's a great point.
And so anyway, I think we need to put resources, time, energy, whatever, into figuring that out.
And I think that may be something we should add to this.
Yep, that's what that's why I scrolled back to the other slide, was to see if there was, why does it keep advancing? Oh, I have to get out of share mode to add. I don't know why that, oh.
And maybe.
Well, you know, this is a document that can be read by people in different ways, not unlike the Bible, the Constitution, and some of our statutes, unfortunately. It's a tough one, Larry. I'm not sure how we draw that balance. I very much want to keep it in mind. But, you know, traditionally at the bar, public protection trumps everything. And so you can only, you know, I hate to use the phrase lower your standards, but reducing cost might mean that to, you know, so far before you are impairing public protection.
Or if, you know, it's not only reducing costs, it's also about increasing revenue. And you know, in other words, some tough choices have to be made. So what if it's about increasing revenue? Well, if you increase revenue, then you have to deal with the accessible, equitable. So it's
a legitimate concern, and we only have about 10 more minutes I'd like to spend on this item.
Yeah.
But I wonder if now's a good time just to talk briefly about what is the source of revenue for this. Is it from admissions fees? Is it from the general fund, and so forth?
So great question. One of the things that I didn't mention that is going to show up as part of the amendments to Senate Bill 253, potentially, is language about how things get paid for, and the language that was preliminarily shared with me, that may be morphing over the next few days, but the language that was preliminarily shared for me makes clear that that the general fund, State Bar's general fund, can't pay for it, right? State Bar's general fund can't give admissions this money for it, and so anything that would be any exam-related costs would need to come from the admissions fund. unless it comes from private philanthropy or right, anything else like that, but it wouldn't come from the State Bar's general fund. And so, and that's why we looked at that slide on what the condition of the admissions fund is, and why it indicated that if the direction is for the next 2 years or permanently an in-person administration at convention centers and hotels, that is going to result, a necessary end product of that is going to be an increase in the fees that are charged to the applicants.
In other words, it's on the backs of the applicants. That's where the funds come from.
Yeah, I mean, and one of the things that's important
And
to
that's-
understand is that is the only place the admissions fund gets revenue, right? And we don't get revenue from the state general fund. None of the bar does. We don't get revenue from the state general fund, and the admissions fund supports the staff in admissions. It supports the costs of administering the bar exam. It supports, right, all of the things that are done are supported by the fees that we get from applicants. It's why we increased some of the fees in recent years, right, to make sure that the cost of performing the service is matched by the revenue that's coming in the door. And as the cost of performing the service increases, then that necessarily is going to result in having to increase the revenue that's coming in the door.
Paul, you were going to say
And
something?
that's a long-term approach, right? I mean, that's nothing new.
Yes.
I don't know if the next gen exam or a combination of that with California would be helpful or not. But have we done any kind of financial evaluation of that?
We don't yet have information on what the costs, the long-term costs for Next Gen UBE are. We do know that, right, the MBE that we are paying for July is $72 per test taker, right? So when we estimated 10,000 test takers, $720,000 for the MBE, we continue to do the essays as we've always done the essays. You know, one of the things that you know, instead of me sort of describing one of the things that Audrey is a proponent of, perhaps Audrey can describe one of the ways that that could be cost savings as well as some innovation in how the exam is delivered.
Right, and at least as far as we know right now, Next Gen is limited to fixed location, which implicates the costs that we're dealing now. Any other thoughts? What is staff asking for today?
So, so there are time limits, and you saw in the report, if the committee wishes, and you don't have to make a recommendation on this, we will, the committee is going to be having a joint meeting with the Board of Trustees. It was originally going to be the week of August the 4th. It may be the week before that, maybe the week after that, the end of the week before that. Or the week after that, we'll be polling for dates. So that decision can be made then, but I do want the committee to start thinking about if the committee wants to return to the Kaplan multiple choice questions in 2 years, then that notice should be given ideally in July. Could be given in August, frankly, because we could technically adjust the timing of the exam by a couple of weeks and have it in August when it is cheaper to get, even if we were still using in-person facilities, it would be cheaper to have in-person facilities in August than in July, right? So I want the committee to start thinking about what do you want to do 2 years from now, and also start thinking about, as the question Mr. Kramer asked that we put on the agenda, Next Gen, because if there is a recommendation to go to Next Gen, we need to keep in mind that the MBEs don't exist as a standalone test after July 2027. which means that as of February 2028, we are either on NextGen or going it on our own. And so if there is a recommendation, if the committee wanted to recommend going to NextGen to the court, then that recommendation has to be made well in advance of February 26, so that the court can consider it, and if that is the direction that they want to go in, then we give that notice in advance of February 26, so we can transition to NextGen February 28. So there are, although that all seems like a long time from now, there are decisions that really need to be made very soon. So I don't know if the committee wanted to adopt the board's principles with the addition of the last bullet of consider how the exam can be paid for, or not, or just move on. We're just, the next slides literally just had, now it's not moving. Oh. Before I couldn't get it to stop moving forward. We're just discussion slides, right? Discussion of short-term administration and development, and then discussion of the new bar exam, California specific or NextGen. So that was the end of the slides.
Donna, you had you mentioned with respect to the July, August timeframe where once that is announced, you committed. You can't necessarily we wouldn't be able to make a sort of a change, or does the clock sort of restarts with any new decision?
Great question. So the language of SB 253, assuming it gets adopted, right? There's that underlying, if this is enacted as written, says that if we say we want to go to something else, and then we want to switch back to the NCBE, to the MBEs, we can do that without the 2-year notice. If we want to go to NextGen, that is a 2-year notice. But if we want to switch back to something to MBE, so if we give the notice in, say, July, and then 6 months later decide, you know what, we're going to stick with the MBE until that's done, then we can go back with a less than 2-year notice. Thank you for that question.
Two-part question. Getting back to finances, does current law prohibit use of general funds from the state bar for admissions? Is it prohibited under the current law?
Good question. So I know the general fund has loaned money to the admissions fund in the past. It does not I don't think it prohibits it outright, but the expectation is that the fund is largely being used for licensees as opposed to admitting licensees. But I think there was an expectation that because of, for example, all of the refunds, having to go in person, that had been sort of some thought that the general fund would supply some revenue to the admissions fund to support everything that has happened since February.
And then the second part would be, is there any thought that the legislature might be persuaded to leave out that requirement, that prohibiting the use of general funds for admissions? Because I would argue that the state bar generally has an interest in admissions, a very large interest, second only to discipline.
Yeah, and so at this point, I'm not in a position to speculate, but certainly those would be conversations that we would absolutely continue to have.
Thank you.
The legislature would also have an interest in that because, getting back to consumer protection, they want a functional bar. Otherwise, the legal profession in the state becomes dysfunctional. I think there are a lot of options or opportunities, but it's probably going to involve some political horse trading. You may have to make commitments to do certain things, blah, 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 blah.
All right. Yeah, well, today we need to decide if we want to adopt some guiding principles. And have we amended the
Mr.
Board of
Chair?
Trustees? Yeah, I'm
May-
sorry.
Mr. Chair, may I
Yeah.
say something?
Michael.
Thank you. Don, I got a question. So, are we required to make an adoption today? And then is there a timeline that we are set for to have to make an adoption?
So you're not required to adopt either the guiding principles today or a decision about stay with MBE or 2 years from now switch back to Kaplan. You're not required to make that decision now. Obviously, we next on the agenda we will be talking about the processes for validating the multiple choice questions. And although the legislation gives us, allows us to sort of put the brakes a little bit on the timeline for it, to be a little less aggressive on the timeline, we will be recommending moving forward with those processes, assuming that at some point either we may be going back to the Kaplan developed multiple choice questions. Maybe for those that are if we don't do that, for those that are in the subject areas of the first year, we have some really good questions that we can just make sure are at the appropriate level for first year, but otherwise they would be solid. But you don't have to make any of those decisions today. I think the board will want to engage with the committee in that joint meeting on decisions about going forward. Obviously, for the next, assuming the legislation is enacted, for the next 2 years, we would be doing the MBE. But we do have to make a decision one way or the other, confirm that we're going with our own exam or not before February 26th.
So if I may make a suggestion that we wait to have a joint discussion with the board before we kind of make a final decision as committee, would that be appropriate, Mr. Chair?
That's fine. I thought today we're not making any decision, we're simply adopting some guidelines, but maybe it would be better to wait, simply wait until we have that joint conversation. So do you want to make a motion?
Julianne does have her hand raised.
Oh, I'm sorry, Julianne.
I just had a general question. Does the state bar have a liaison with the legislature or some other staff that kind of, tells them these are the effects of the, possible legislation that will happen, from our view, seeing all this kind of, more on the ground than maybe the legislature does. And then kind of, seconding that, I think this is a discussion maybe for later because so much depends on whether that legislation will be passed or not.
The short answer is yes. And Donna?
And it's me. So I serve as both the chief of admissions and the legislative director. So I'm in a good position to hear what the committee is saying and be able to convey that.
So, Mr. Chair, would you like me to make that motion?
Yes, if nobody else has any other comments. Julianne, did that answer your question?
That did, thank you. I was just making sure that, our voices kind of heard as a legislature that, that this may unintentionally cause a bigger mess than they, I think, realize might happen with their wording.
Sure. Yes.
So I'd like to make a motion to table this decision until we have a further discussion with the Board of Trustees in our joint meeting, or something to that context.
Yeah, I think you got to set a date.
We don't have a date yet.
Oh, okay. Well, county council, I'm not county, state park council.
All right.
Yes. No, not yet. It's early August.
It's gonna.
So that is the motion. Is there a second?
I'll second that. Alex
I'm
Lawrence.
sorry, Alex. Keep forgetting you're over there. Is there any further discussion on this? Devin, can you take the roll on Dr. Cow's motion?
Dr. Bolton?
Yes.
Dr. Cow?
Yes.
Kareem Gangora?
Yes.
Larry Kaplan?
Yes.
Paul Kramer? Paul Kramer?
I'm unmuted, I thought. Yes.
Alex Lawrence?
Yes.
Esther Lynn?
Yes.
Justice Macy Walla, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes?
Yes.
Judge Reyna, not present. Ashley Silva Guzman?
Yes.
Julianne Smith?
Yes.
Alan Yokelson?
Yes.
Alex Chan, not present. With 11 yeses and 0 nos, the motion passes.
And we captured that as tabling the discussion until the joint meeting with the Board of Trustees and the Committee of Bar Examiners.
That is correct. Let's move on to item 4.2, adoption of criteria for selection of subject matter experts for the bar examination and multiple choice content validation process. And then we're going to discuss with that item 4.3, adoption of criteria for selection of content validation and standard validation panelists. Cody?
Yes, thank you so much. Let me get my screen shared here.
Thank you.
Okay. Everyone can see that?
Yes.
Great.
Yes.
Okay, so yes, we are combining this presentation for both item 4.2 and 4.3 because there is, to some extent, a good deal of overlap between the two staff reports, and they're part of kind of the chain of content review and validation. So it makes sense just thematically to discuss them together. Before I get into the specifics, I just wanted to note what we are proposing in combination of these two policies is adopting criteria for selection and recruitment of individuals to serve on panels that members here are already familiar with. Our content validation panels that review, draft multiple choice questions and provide feedback, and our standard validation panels, which assess the performance of both the multiple choice questions and the written questions on the exam and recommend to the committee a raw passing score for the exam. What is new in the process, and I'll describe this in more detail momentarily, is an additional layer of subject matter expert review that we plan to implement kind of towards the end of the content drafting process to add an additional layer of review focused entirely on legal accuracy. And I'll get to that in just a second. So what is the purpose of these two proposed policies? And the policies are included in the attachments to the agenda items. First and foremost, the policies and bringing them here today for this discussion are meant to ensure that the committee has appropriate oversight over the development of these processes and also approval of the selection of individual panelists and subject matter experts. With the addition of the subject matter expert review, the SME review for legal accuracy, we believe that adding an additional layer is an opportunity to further enhance our multiple choice question review process. And of course, when we have worked with panelists and other contributors, there are always agreements that we develop with input from council, but what we would like to bring to the committee today is a policy for the committee's approval, really focused on establishing eligibility criteria that more clearly reflects our attempts to prevent conflicts of interest among participants, mitigate any legal risks and copyright copyright infringement risks. As always, there's a level of exam security and integrity protection built into the policies that we adopt when we recruit and allow outsiders to contribute to our work. So I wanted to just to color this discussion as we get into more of the specifics of the tasks that these individuals are asked to perform, just to remind the members kind of at a 30,000 foot level what the multiple choice question review process looks like. So currently questions are drafted, they are reviewed by content validation panels. Content validation panelists provide feedback that goes back to our question developers who then make revisions. And that you can see here kind of this two-directional arrow, which is meant to communicate that this is an iterative process. Content validation panels provide feedback, questions are revised, and if necessary, questions can go back with additional feedback for further revision until they're satisfactory. What's after that in the chain is this new additional subject matter expert review. And you can see here, similarly, we imagine this to be an iterative process with SMEs providing their assessment of the legal accuracy of a question, that feedback going back to the drafters, questions coming back to the subject matter experts, and again, that can be iterative until it's sufficient. We then have our copy editing process, and then after the exam administration, we have our standard validation panels, again, that meet to assess the performance of the questions, and I'll describe that in more detail in just a moment. So what do our content validation panels look like? Our content validation panels, according to the policies that we are proposing, are comprised of law school faculty, recently admitted attorneys, and supervisors of recently admitted attorneys. This is the makeup of panels as they existed prior to this policy because there were previous iterations. Panelists are trained and they're led by assessment specialists and our psychometricians. So before there's a review process, they are given kind of a primer on how to conduct these panels. Panelists are tasked with assessing the multiple choice questions for their appropriateness, whether or not they appropriately attest for minimum competency, whether they're free from bias, whether they're clearly written, whether they align statistically stylistically with other questions, and whether they accurately test the intended legal issue. And again, it's an iterative process, so panels can provide feedback, review the questions again. What we imagine for these future content validation panels is re-reviewing existing multiple choice questions. So questions that already went through the review process, we imagine that these panels would not only review future questions, but also revisit questions that have already been reviewed. I want to note when it comes to the content validation panels, we believe that it's most appropriate for there to be a separate content validation process, similar in its procedure, but that's conducted by our EDGE team and performance test review teams for the content validation of the essays and performance tests questions. As I mentioned, we've got this additional level of subject matter expert review that we're adding to the process. This group is comprised of law school faculty and also retired members of the California judiciary. We imagine recruiting 3 for each of the 7 tested subject areas for a total of 21 subject matter experts. I want to be clear, these individuals will not be drafting or revising questions directly. What they will be tasked with is reviewing multiple choice questions for legal accuracy only. So what they'll be asked to do is an open book review of the questions. They will be asked to cite explicitly the legal sources, the law that they are citing in making a determination of a question's legal accuracy. And again, this will also be an iterative review process. And then lastly are the standard validation panels. So a new standard validation process is required for several reasons. One, if proceeding with multiple choice questions that are not those developed by the National Conference of Bar Examiners requires that we perform a standard validation because our exam scores cannot be anchored to questions that we previously purchased from the NCBE. Also, we conducted a standard validation after the February exam of February 2025, but because that exam presented unusual circumstances, we believe that another standard validation will be necessary after a future exam in which the questions, newly drafted multiple choice questions, are utilized. The standard validation panels are comprised of law school faculty, recently admitted attorneys, and supervisors of recently admitted attorneys. And what they're asked to do is to assess the performance of a minimally competent attorney. So what that means for the multiple choice questions is what questions is a minimally competent attorney expected to answer correctly? And when it comes to the written questions, it's making an independent judgment about the expected performance on those written questions. So ultimately, panels recommend a raw passing score for both the multiple choice question component of the exam and a written portion of the exam. So that's just a primer of the tasks that these individuals are asked to contribute to. The heart of the proposed policy and what we are essentially seeking the committee's approval for today are the proposed eligibility criteria that are presented in the attachments. And so I want to quickly go through those criteria and just identify where they apply to subject matter experts and where they apply to panelists and whether there's any distinctions between the criteria in either of those groups. So the first criteria that applies to both subject matter experts and panelists are that they must not have an immediate family member or close personal relationship with someone who will take either of the 2 California bar examinations that immediately follow the beginning of their engagement. I should note when these contributors are reviewing questions, they do not know which questions will be used on an upcoming exam, and they're asked to review questions that go into a large item bank. And so an appropriate safeguard needs to be put in place, and we are proposing 2 exam administrations. Both must not have been engaged in commercial activities related to bar exam preparation in the 2 years immediately preceding their engagement, and they also cannot engage in those activities while they're participating. Both SMEs and panelists must not have performed work directly or indirectly for the NCBE in the year immediately preceding their engagement, and they cannot perform that work while they're participating with the state bar's processes. Now, here's where there's 2 additional requirements for panelists that don't apply to subject matter experts, and I'll explain why in just a second. For panelists, one proposed eligibility that applies is that they must not have had a license or an agreement with the NCBE or with any bar preparation company relating to the use of its intellectual property, and that includes exam questions, at any time in the 3 years preceding their engagement. The second is that a panelist must not access, refer to, or use any exam questions from the NCBE or another bar preparation company during their work with the state bar. And the reason these apply to our panelists and not the SMEs is because, as I mentioned earlier, the subject matter experts are not asked to draft or revise questions. They're purely looking at the legal accuracy of questions. Because panelists are providing feedback that ultimately determine the content of the questions, we believe that these additional safeguards or eligibility criteria are necessary. The remaining criteria that are proposed, panelists and SMEs must be able to represent that participating in the review will not violate an agreement that the SME has with the NCBE or bar preparation company. All SMEs and panelists must be an active licensee in at least one state in which they're licensed, and they must be in good standing in the state in which they are licensed. I want to note that for members of the California judiciary, we are recruiting only retired members, but even those retired members should still be or must still be licensed in a state under this policy. And lastly, both panelists and SMEs must agree to disclose any changes that may create a real or perceived conflict or would otherwise impact their ability.
Cody, perhaps we can open it up for questions now. We're keeping a tight eye on the clock in light
Yep.
of the full agenda.
Yeah.
Kareem, I think you
Yes.
had
Awesome.
questions.
Thank you. Cody, thank you for your presentation. At what point would law school deans participate on this process?
Yeah, so law school deans are not part of the cohorts that we would be recruiting to participate in these groups. Mostly because what informs the types of individuals that are appropriate for this type of work are one, either the fact that they themselves are a recent active licensee or that they were recently licensed, or someone who is often working alongside or with recent licensees. So that can include faculty, that can include supervisors of newly licensed individuals. We have not generally included deans in that process. I do know, of course, we have our other engagement opportunities with our law school deans, whether it's CS bars or some other type of outreach or engagement.
But to the extent that they are also serving as law school faculty, they would participate in that category.
True. Yes.
So my question stems from the concern that we received probably in our February or March meeting in regarding to their lack of participation or exclusion. So in terms of their participation, how many members get access, I guess is what my logic is moving me towards.
So there are a couple of things that we're doing. One, going through the deans to help us do the solicitation for the subject matter experts, as well as the content validation panels and the subject matter experts. Also, I've communicated with the deans of all of the schools and indicated a desire to improve communication, perhaps a quarterly meeting, which Audrey and Natalie are have come up with a project plan for that I just need to review and get that out the door. But that is something that we are absolutely committed to doing, is having a more routine and robust engagement with the law school deans to apprise them of what we're thinking, to hear what they're thinking, and to consider their feedback. So that is a very important part of this plan, is improving that engagement. So that doesn't necessarily mean them sitting on these panels. Certainly some deans could be sitting on these panels, but the panels aren't going to be geared toward heavy dean involvement.
Yeah, and I guess for me, I know there's CS bars that operates as some type of connectivity to the work that we do. I guess it's just that was one of the, in my opinion, one of the lessons learned from the February was that there were and there's moments where we're not always going to agree or have continuity in ideas, but that was something that I took away from it, from their testimony and their continued advocacy. So I appreciate your taking that plan and integrating them somewhere. So thank you.
Paul, did I see your hand before?
Yeah, I lowered it.
Okay. Does anybody else have any questions or thoughts? Okay, Cody, do you want to finish up your slides and then we can. All right.
Yeah, that would be my recommendation.
Okay, can we put the motion up on the board? On the screen?
Sure, 1 second.
Oh, Alan, I did have one question. Sorry.
Yeah, go ahead, Paul.
Just so copy editing is occurring after all the technical reviews are done, right before the question is administered. Should we be concerned about the possibility that a copy editor could inadvertently introduce a problem by virtue of changing a few words?
So the answer is always yes. we should be concerned about anything. We are, the copy editor is required to make any suggestions, in-track changes, and to the extent that there could be anything, like there was a suggestion on one of the questions about a word choice. And we went back and talked with Adrian, who said, no, there was a significant conversation in the content validation panel about that word and whether that word should be used or not. Well, we're not going with the copy editor then, right? To the extent that there is a question about whether it is introducing a substantive change, then our plan is to use Edge team members as sort of a decider of those kinds of questions, right? Not leaving it to staff. I mean, staff can look obviously and say, yes, that's a purely grammatical change. But things that may not be, then we'll make sure that we've got a subject matter expert taking a look at it to ensure that it doesn't introduce any issues.
Okay, thanks. Edge wouldn't be looking at a multiple choice, would they?
We have, in fact, asked them if they would play that role, or we've started that conversation. Some of them may be hearing this for the first time, but we have talked with the leadership of the Edge team about that very thing.
Okay, thanks.
And then I had a quick question just to confirm. I think there were someone made a public comment about having expertise in the development of multiple choice questions as kind of like a separate skill. And I think there was mention that there would be training on that. Is that correct? Or can you explain a little bit more about what kind of training on specifically multiple choice questions and how to develop them these panelists will get?
Yeah, I could share some quick thoughts on that. The content validation panels, it's a bit of a fine line because we want subject matter expertise and we want these individuals to contribute to the refinement and revisions to these questions. But at the end of the day, what we're seeking the most from these individuals is their insights in helping us assess whether a question is a good question to measure minimum competency. And so we're looking for those supervisors of recently licensed attorneys, the recently licensed attorneys and law school faculty, because they're closest to that understanding. So of course, I think experience drafting questions would be of interest as we're recruiting individuals, but it's not a core competency to contribute to a content validation panel. And of course, what we will expect of the drafters themselves is that they bring, I think, those strengths as the individuals drafting the question, not the content validation reviewers. As far as the training is focused on participating as a content validation panelist, not training on necessarily the methods of drafting multiple choice questions as a skill set independently.
All right, can we share the motion?
And I just want to be clear, I believe there's two separate motions they're nearly identical. One is for 4.2 related to subject matter experts, and then a similar one for 4.3 related to our panelists.
This is Michael, make that motion.
Would that be for both?
Yes, to both motions.
All right, Duke. Michael Cow has moved. Do we have a second?
Yeah, I'll second for both motions. This is Vince.
Vince Reyes seconds. Any further discussion? Devin, could you call the roll, please?
Dr. Bolton? Dr. Cow?
Yes.
Kareem Gangora? Kareem Gangora?
Yes.
Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence? Alex Lawrence?
Alex stepped out of the room.
Esther Lynn?
Yes.
Justice Macy Walla, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan, not present. With 10 yeses and 0 nos, the motion passes.
Thank you. We're going to move on to item 4.6. Next on the agenda, it's a discussion and possible action on the preliminary review of the Supreme Court proposed amendments to its rules of court related to responsibilities of CBE. Dawn is going to present this item, and we're going to allow about 30 minutes of discussion. I'm really trying to get us back on track because we still have much material to go through. So Donna?
Thank you. Let me share my screen. Oops. So there was a fairly brief staff report for this item. As everybody is aware, the Supreme Court provided a draft set of rules in part intended to clarify the responsibilities of the Committee of Bar Examiners, the Board of Trustees, and the Supreme Court with regard to a number of the issues that come up in this admission space. So my goal for today, for our discussion today, is to highlight the amendments regarding key CBE responsibilities and changes to the roles of the board and the CBE, to solicit the initial feedback of this committee, and if the committee chooses to take action to record the CBE recommendations pending the review of public comment. And so as a reminder, the Supreme Court issued the draft rules and requested that the state bar circulate the rules for a 45-day public comment period. The rules are currently out for public comment. The public comment period closes end of day, 11:59 p.m., I believe, on July 14. I don't have an update at this time about the number of comments that have been received or any general tenor of those comments. And so the idea here really was to get some initial feedback from the committee on the proposed amendments. The plan is that the committee and the board, and this was the original intention for that joint meeting that's coming up in August, that the committee and the board will meet together, the committee having first had this conversation today, the board having a similar conversation amongst its members on July 3rd, you all coming together the week of somewhere around between August 1st and August 11, and coming up with a recommendation based on your individual inputs as well as the public comment that will have been received and will be analyzed for you by the time of that meeting, to together come up with a recommendation for what to inform the court about the amendments, about the proposed rules, and any further amendments that the committee and the board recommends. So the basic topic areas that the rules, the proposed rules covered: oversight of the bar examination, administration, development, and grading. We rolled into that a topic that the Supreme Court referred to in its press release as examination reform. That's part of exam development, as how we're describing it. Administrative and fiscal authority, governance and appointment procedures, and then we've got other here in case there are issues, other issues that are touched on by the rules that the committee would like to weigh in on. I will also point you to attachment A in the staff report. Attachment A was developed by our Office of General Counsel, and it goes through, using the same general categories that we have here, goes through the different proposed amendments, whether what is proposed is new in part or not, and whether it increases the authority of the CBE or board, and if so, who, as compared to current. And so I just wanted to point that out to you. So looking now, so looking now at a general sort of high-level discussion of what's included in the proposed rules. When it comes to the administration of the bar exam, again, under our overall heading of oversight of the bar exam, with regard to administration, the rules provide that the Committee of Bar Examiners is responsible for administering the bar exam. It's responsible for developing standards for accrediting a third-party vendor to administer or proctor the bar exam in person, remotely, or some combination thereof. And that responsibility of the CBE is subject to review by the Board of Trustees. It also indicates that the CBE is responsible, as part of test administration, of developing standards for testing accommodation subject to Board of Trustees review. You'll see in attachment A that is identified as an increase in authority for the Board of Trustees, because the Board of Trustees certainly approves rules that are recommended by the Committee of Bar Examiners when it comes to testing accommodations, but currently they don't adopt standards coming out of the Committee of Bar Examiners. When it comes, so then looking at exam development, the rules provide that the Committee of Bar Examiners may use a third party to create content subject to approval of the Board of Trustees, and then specifically requires that the CBE attorney and judge members or the content validation panel must review all bar exam questions before they're administered or released. And by released, it specifically references the student guide or the faculty guide, which is what we did for the multiple choice questions that had been developed for the State Bar's exam for February. This provides an increase in authority for the Committee of Bar Examiners because the committee has not, up until now, has not been reviewing multiple choice questions. Certainly you review and select the essays and the performance test questions for the exam. This may need to be modified because to the extent that the multiple choice questions being used are the multi-state bar exam from the NCBE, the committee will not have the ability to review those questions in advance and determine whether or not individual questions can be used. So this language would probably need to be modified just to reflect that it's to the extent that these are developed specifically for the California exam. Further, on the development, on the bar exam development side, the rules provide that the CBE would be responsible to develop qualification standards for the content validation panels and the subject matter expert. And those would be subject to, and doesn't say this here, but would be subject to review by the Supreme Court. And so that's why the prior bullet talked about the CBE attorney or judge members reviewing all the bar exam questions or having the content validation panelists review. That would be a choice that the CBE gets to make, whether you want to review them yourself or if they are reviewed by content validation panelists that are selected pursuant to policies and guidelines that you have set up, selection criteria that you have set up. Maybe your confidence then lies with them doing that review of those questions. Also, under what had been in the Supreme Court's press release identified as exam reform, this requires the CBE, under the oversight of the board, to conduct analysis of the validity of the exam at least once every 7 years. There's a current requirement that talks about the state bar conducting the analysis of the validity of the exam every 7 years. So this is specifically saying this is a CBE responsibility under the oversight of the board. And then finally on this slide, and I think when we're done with this slide, I'm going to stop and ask for questions before we move on to the next subject areas, which deal with the administrative and fiscal authority. And so the final slide here, final points here relate to all three: administration, development, and grading of the exam. The language requires a cost-benefit analysis for any changes to the exam. I think it's a cost-benefit analysis for any changes that require the notice of the substantial modification. The Supreme Court to approve any substantial modification of the exam. The Committee of Bar Examiners to oversee the grading process and develop standards for regrading and for any scoring adjustments subject to review by the Board of Trustees. This was identified as something that was increasing the authority of the Board of Trustees, in that the Board of Trustees currently is not involved in developing the process for and making decisions about standards for regrading or for scoring adjustments. Those have gone, as you saw most recently, from the CBE directly to the Supreme Court. And then also there's language about the Committee of Bar Examiners recommending the passing score to the Supreme Court. So I thought I'd stop there before we move on to the fiscal and administrative authority and see if there's any discussion that you all wanted to have about those items. I'm going to take the screen, my stop share.
Isn't there a graphic that showed what it is now and what it will be? Did you guys see that?
So yes, so there's attachment A.
Yeah, that one.
Yes, attachment A in the staff report.
All right. Are there any other questions? Thank you, Donna. You want to move on?
I certainly can. Mr. Kramer, I know you had some thoughts, though, and I wanted to make sure you have an opportunity to raise them if you'd like to.
Everyone thanks you for that. I think they come after your next part.
Okay, I will share my screen again. Okay. Next. Administrative and Fiscal Authority. The CBE shall regularly review the revenue and expenses for the admissions fund. This is an increase in the authority for the CBE. The CBE shall also propose a budget for the Office of Admissions. We are anticipating bringing the Chief Financial Officer and the director over the budget to the August CBE meeting to do a look back and a look forward. The look back, just sort of looking back at the history of the admissions fund and how we got to the condition we are today, and the look forward, talking about the process for involving the committee and proposing a budget for the Office of Admissions. The process would include before the proposed budget goes to the Finance Committee of the board and before it goes to the full board, bringing it to the Committee of Bar Examiners. Our finance office wants to get to a point where they have fully developed their thoughts on the budget and then present that to the Committee of Bar Examiners for your input and discussion and analysis. Also, again, additional fiscal authority that increases the authority of the CBE, provides that the CBE would be responsible for setting fees subject to approval by the Board of Trustees, fees related to the bar exam, law school accreditation, registration and inspection, moral character, and special admissions programs. Also, on the administrative front, also increasing the authority of the Committee of Bar Examiners, reinstating the Committee of Bar Examiners' authority to issue subpoenas in admissions matters. I know this is something that our Office of General Counsel is taking a look at simply because there was a statute that had provided the authority of the board, the committee of bar examiners, and any other committee to take and hear evidence, administer oaths, and compel attendance or documents by subpoena. That language was repealed, and so we just want to ensure that that this rule is not prohibited by the repeal of that statute, which provided that specific authority previously. Questions before moving on to governance and appointments?
Where would we be subpoenaing documents historically?
So I'm not aware that the Committee of Bar Examiners ever used this authority when this was authority that you did have. If I were to hazard a guess of a situation where it could come up, I guess it would be moral character. But when you submit a moral character application, you are agreeing to provide all of the information that we need in order to assess the moral character. So, but that's the one area that I can think of.
Okay, seeing no questions. Donna?
And the next category, governance and appointments. So this is just the first two are just deal with appointees to the Committee of Bar Examiners, and the third item here talks about responsibility, a new responsibility for the Committee of Bar Examiners. So so the first, just spelling out specifically that the appointees that the Supreme Court appoints to the Committee of Bar Examiners, right? The Supreme Court, as you recall, appoints 10 members to the Committee of Bar Examiners. Their appointees cannot be regular or adjunct professors of law or actively involved in bar exam review courses. The appointees cannot be involved in assisting applicants in fulfilling requirements for admission or member of a board or committee of a law school. It does specifically exclude from that if you're a member of like the alumni committee, that would be excluded from that limitation. And then finally, the rules provide that the committee can recommend to the Board of Trustees candidates for the director of the Office of Admissions. And I just note here that it probably, instead of the director of the Office of Admissions, it should actually be recommending candidates for the Chief of Admissions, which is my position. And currently, the Board of Trustees is not involved in the hiring of anybody but the executive director of the State Bar, the general counsel, or the chief trial counsel. And so really what I think this language probably should be is that the Committee of Bar Examiners can recommend to the executive director candidates for the chief of admissions. There are or will be multiple directors of admissions. We've talked in the past about the revised organizational structure for admissions that we've implemented the last couple of months. And so Audrey Ching, as the Director of Admissions Operations, will have a counterpart, a director over exam development. And so it just doesn't make a lot of sense, sort of the language as it's currently structured in light of the new structure for the committee to be recommending candidates for the Director of Admissions, because that will be sort of multiple roles. And I think more logically, it would be the Chief of Admissions. And that's all I have.
Paul, did you say something?
No, I was about to though.
Go ahead.
Let me just dialogue with Donna for a minute. I marked this thing up. She was kind enough to provide me with a Word copy because it was really hard to mark up the PDF that we received. And it's fair to say, I noticed things that don't even relate to us. For instance, there's a place where the right of the bar staff to appeal certain decisions to the Supreme Court of the State Bar Court was written in such a way that it seems to preclude, say, the applicants who are the subjects of the court decision from appealing to the Supreme Court. And I'm sure that was an error. So I have many suggestions to improve the language along those lines. I don't know that, I'm pretty sure you don't want to hear all those today, but I want to find a way that we can get those into the record, because I think, this is an opportunity to make this rule even better. The one thing I do want to suggest on behalf of, or maybe two things. The way our authority to regulate law schools is described, I think, is a little problematic potentially. It talks in terms of us regulating, I'll have to find it here. Law schools conferring a Juris Doctor degree in California. I'm not sure what that means. If it's an attempt for us to register the behavior, regulate the behavior of schools that don't have a situs in California, there might be some constitutional issues there. I think what we mean to say that we can say that any school that's issuing a Juris Doctor degree that is intended to be used to become a member of our bar, we can say what those schools have to have done. But I think maybe it's not as artfully said here. And so that's one change. The other one is there's a description, very little is said about how we regulate law schools, except all of a sudden there's a description of what has to be in the law library for a school. And it I think is incomplete the way it is, because it just refers to California materials. So I think this would be a good opportunity for us, if the court is willing, to have the court just say, we need to describe what's required for law libraries, but leave the description of that, the details to us, because we're in a transition period where more law schools are going to online-only education. And for them to have a physical library doesn't make a lot of sense, but they still should provide access to library, whether maybe it's online legal research materials and instruction and all that to their students. So rather than junk up these rules with those details, which we haven't worked out yet, how about we get them to just say, do it, delegate it to us. I think they're trusting in us enough to be willing to do that at this point. And then there's probably other changes. So Donna, how do we get this communicated to them? I don't know that the rest of this body cares about some of the details I spotted, so I don't want to take up a lot of their time.
Well, it seems like, Paul, you've already done a lot of work there. Maybe staff can take that and prepare it as a proposed comment on behalf of the committee that we can take up at our next meeting.
Well, not even necessarily as a comment, but we can add sort of alongside the public comments that were received, and we'll be analyzing those comments received from the Committee of Bar Examiners or individual members of the Committee of Bar Examiners. And so I'm happy to work those up. Paul has given me those. But just to talk about the last point that Paul made, and this is in Rule 9.30, which is found at page 21 of the PDF of the court's order. So there is specific language that talks about, actually starting on page 22, and this is existing rules where Paul has identified these things seem problematic, but there's a requirement that the schools own and maintain a library consisting of, and there's a specific set of materials. And I think Paul's suggestion is something like own and maintain a library consisting of items that are determined by the Committee of Bar Examiners, something along those lines. And I did have a preliminary brief conversation with the Supreme Court liaison just to inquire, is the court, would the court be willing to hear suggestions that are beyond sort of the issue of the roles and responsibilities of CBE versus the board versus the court, but an issue like this that Mr. Kramer raises. And they indicated yes, they'd be happy to take a look at that if that is what the committee and the board want to recommend. So no limitation from our liaison on being able to work that language up and submit that if that's something that everybody agrees should be changed. So that will absolutely can be put together for the item that goes to the joint meeting. Everything that Mr. Kramer has provided to me.
Okay, that takes care of me then.
So then with that, there may not be a need for a motion at this point.
Mr. Chair,
Okay.
can I add to what Donna just mentioned? I think that we shouldn't take a motion at this time. I think that given the significant amount of information that we need to kind of digest, and also with the benefit of the upcoming joint meeting, that we should maybe wait before we make a decision on this until after the joint meeting.
If we need a motion to do that.
You don't.
Okay,
We can
sounds
just
good.
do it.
All right.
Okay. All right, thank you. So moving on to chair's report?
Moving on to the chair's report.
Chair's
We're
report,
pretty much back on time.
Okay. Chair's report, item 1.1, oral report. At this time, we don't have any information to report. So I'll move on to 1.2. Next on the agenda is the adoption of revisions to the Committee of Bar Examiners Work Plan. This is being presented again by Donna.
And I should not have signed out of the Zoom meeting, but I did. Audrey, would you be willing to share the work plan?
Sure, give me 1 second.
We're going to spend about 20 minutes on this, folks.
Audrey, I have it up. Do you want me to share?
Oh, great. I'm still like 3 clicks away. Thanks so much.
Okay.
Thank you. So staff went through the work plan because we've been doing a lot of thinking about everything that's on the committee's agenda for the near future. The exam administration and exam development subcommittees, which we'll be talking about next, and the work that will be involved in talking to and getting presentations from vendors of different platforms, remote and in person, exploration of what might be the best way to go for that, doing the work with content validation for the multiple choice questions, the new provisional licensure program, which was just approved by the court that staff will have to get operational and implement that by September 1, and monitor very closely the many different deadlines that are in that rule of court. Just sort of looking at a variety of everything that needs to be done. And so we went through the work plan. And what you have in before you here on the screen and in the report is the work plan as we last presented it to you on April 18. And we have added 2 columns. Subcommittee assigned, if these are going to go to either the exam administration or exam development subcommittee or be within their purview, and then what staff's proposal is, i.e. should something be removed from the work plan, revised, move to a future year, or adding something. And so we laid out for you everything that we think is necessary in order to be able to manage agendas that are likely to be the size of the agenda that we have today for a little while. And as a result, we are proposing moving a couple of things to 2026 or 2027, removing things that have been completed. Obviously, that won't add to the work plan. It'll add to our workload. It'll just clean up the work plan. Revising the wording of some of the things on the plan. Adding, I just want to look because there's one thing that I may have added that we can actually take back off. So edit and approval of final versions of the multiple choice questions for administration on California bar exams. adding, develop a plan to ensure appropriate CBE oversight over exam development issues. I just want to see the things that we've added. Adding the provisional licensure program, including reviewing key participation data, including makeup of the participants and experiences with the supervisors, because that's certainly something that we've heard about in the past. Some concerns really came to part of the discussion more heavily with the portfolio bar exam and some of the experiences that happen in Canada, and so we want to make sure that we are attuned to that. I also added to the work plan something that can now be taken off under the heading of Operations and Management One-Time Assignments. It is on page 11 of the work plan. I had added develop a rule proposal if AB 1522 is enacted, outlining a process for expediting licensure to practice law without an exam for attorneys meeting the criteria. And this bill was about attorneys who worked for the federal government as of January 2025 and developing a process for expediting licensure for those attorneys without having to sit for a bar exam. AB 1522, I just learned, is not going to be moving in its current form this year. And so we can, that's something we don't need to add to the work plan for 2025 because that is not something that is going to be happening. I did also recommend adding a review of procedures and key statistics for the revised service member and military spouse special admissions program that we talked about earlier today. And so I just wanted to sort of highlight those. I hope the committee has had an opportunity to review some of the things that we're suggesting moving or removing. One of the things that I do want to point out is we made some recommendations about some of the trainings that we typically have at committee meetings and made a recommendation that we would record trainings and make those available for CBE as opposed to live trainings. Again, just because of the likely fullness of the agendas for at least several meetings to come, and this is something that we can absolutely revisit with the 2026 work plan. And so with that, I'm happy to take any questions or suggestions for revising what we have proposed here.
Paul?
Yeah, Donna, a couple of removals I'm wondering about. The first is continue with the productive mindset intervention. It's to be removed, but yet it's going to be given at the in connection with the July of this year exam. And I think normally when we've created something like this, we like to receive a report about what happened and what the lessons learned were. So I think it should stay on to that degree.
Yes, I'm happy to revise it to just talk about providing an update or report to the committee about the efficacy of the program. I took it off because it has become at this point more of a staff to-do list, and this work plan does not reflect everything that admissions staff is doing. It is more about the work that the committee is doing. But yes, certainly we can revise it to reflect, receiving. I'll look back at some of the other ones that we talked about sort of receiving, key data and updates on the impacts of the program.
Yeah, the same for the strategies and stories program on page 5, the bottom.
Yep. So same. We'll give you those reports together.
Okay, and then for the recorded trainings, to the extent those are not non-public or the information is, can we make them available for the public to look at as well?
Yes.
So maybe they could become YouTube videos and be linked on the, our agenda pages.
Yes, I think it's a
So
fabulous
people know.
idea. Fabulous idea. To the extent that we would have provided the training in open session, then we, if the content remains appropriate, remains content that would be in open session if we did it live, absolutely, I think that's a great idea. We should put that recording online and have link to it on the admissions webpage.
Can we get CLE?
Possibly.
Possibly. Seriously.
Oh, then we have to write more questions, Alan. Do you really want to do that?
You're right.
Hold on, one more, at least. I made the notes in a program that keeps them super small on my screen. Oh, do we have any work to do? Oh, you've added provisional licensing. Never mind. Let me scroll. Somebody else wants to ask a question while I'm checking my notes. Go ahead. Looks like that's all I have. Thank you.
I know we removed, I thought I saw in here removing admission ceremony. I know. CLA.
I think it just went to the parking lot.
The admission ceremony?
Yeah, I think I said put it.
Yeah, it's on page 19 for next year only. So
I'll just say that CLA is still interested in doing it, but I'll bring that up with them separately.
oh no, it's 2027.
Yeah. We're okay. All right.
So, Devin, did I give you a reso for?
Yeah, let me share.
Oh, there it is.
So moved.
Moved by Paul Kramer. Is there a second?
Let me just make sure we are reflecting as reflected in attachment A and, right, because we discussed changes, and as.
And such changes as were discussed.
There we go. Thank you. My brain is turned off. Okay.
As discussed. Is that a comma or a period?
It's a comma.
Oh, yeah. Okay. All right. Paul Kramer moves. Is there a second? Do I have a second?
This is Mike. I'll second that.
Dr. Cow seconds. Devin, please call the roll.
Dr. Walton? Yes. Dr. Cow?
Yes.
Kareem Gangora?
Kareem had to leave.
Okay. Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence? Alex Lawrence?
Alex stepped outside.
Esther Lynn? Justice Spacey-Walla? Not present. Joshua Montgomery? Not present. Bethany Peak? Not present. Vince Reyes?
Yes.
Judge Reyna? Not present. Ashley Silva Guzman?
Yes.
Julianne Smith?
Yes.
Alan Yokelson?
Yes.
Alex Chan? With only 8 votes, we do not have a quorum with members that have stepped out.
All right.
We have a majority of those present and voting, but we also, Mr. Lawrence will be coming back in a moment, so we can take another vote then if the committee would prefer to do it that way.
That's fine. Let's move on to the next item then. All right.
The next item was 1.3.
1.3?
1.3.
Yes. Yes, this is the adoption of charter and membership of Subcommittee on Exam Administration and Subcommittee on Exam Development. The item is being presented by Donna.
So this is a follow-on to a discussion that the committee had at its last meeting. The committee did approve the formation of these two subcommittees contingent on having the opportunity to review the charters. And so this item presents to you the charters that were drafted by the chair of the committee, Alex Chan, and for both the Subcommittee on Exam Administration and Subcommittee on Exam Development. So on behalf of Mr. Chan, I will ask the committee, one, to formally confirm their prior action to establish these subcommittees, and then seek volunteers for participation on these subcommittees.
Has Alex returned, Donna?
And to adopt the charters.
I'm sorry, Donna, we can't see, for those of us online, we cannot see when members have stepped out. So I'm not sure if Alex is back yet. If he's not yet back, I suggest we take a 5-minute break because this is going to require a quorum to take action.
Right.
Yeah, we're due for a break.
We're due for a break. All right. Let's take 5 minutes and we'll reconvene in about 3:20. Thank you. And I'm texting Alex. Oh. Devin, are we back? We're back live.
We
All
are.
right.
We are.
Thank you. Devin, could you go back and let's take a roll call on 1.2
And let's show the resolution.
and show the resolution again.
Sure. 1 second. Jean, do we need a first and second, or?
I think we had those, did we not? Are folks willing to remake those? I think, Paul, you moved. Was
And
that-
Dr. Cow second.
Sounds right.
And
Stand by it?
So first by Paul, it was a second by Dr. Cow.
Correct. If we could call the roll.
Dr. Bolton? Dr. Bolton?
Here.
Dr. Cow?
Yes.
Kareem Gangora? Not present. Larry Kaplan?
Yes.
Paul Kramer?
Yes.
Alex Lawrence?
Yes.
Esther Lynn? Justice Macy-Walla? Not present. Joshua Montgomery? Not present. Bethany Peak? Not present. Vince Reyes?
Yes.
Judge Reyna? Not present. Ashley Silva Guzman?
Yes.
Julianne Smith?
Yes.
Alan Yokelson?
Yes.
Alex Chan? Not present. With 9 yeses and 0 nos, the motion passes.
Thank you. So we're going to continue with 1.3.
1.3. Yeah, we need a motion.
Can we? Well,
volunteers.
we need volunteers, yeah.
I had a question first.
Yes, Paul.
Well, or a comment. The exam administration charter speaks to coordinating with the CBE, but the exam development charter doesn't mention us at all. Which does that mean we're just sending this thing off to do whatever it wants to do and not keep us posted or seek direction from us occasionally? I would be against that.
I would expect that Mr. Chan would be against that as well. So are you thinking of taking the last, something like the last bullet point on Subcommittee on Exam Administration and adding that to the Subcommittee on Exam Development Charter?
Yeah, and for both of them, there's something that to the effect that they shall periodically update the full committee on their activities might be good.
How does it work with any other subcommittee?
It's a subcommittee of the committee, bar examiner. So you can direct them to report back as often as you would like them to report back, regardless of whether it's in the charter. But there's no harm in putting it in.
Okay.
So let's put it in.
No, here it's a reminder. Well, to the extent we ever look at these things again.
So we are adding to both of them to periodically update the CBE. And then to the Subcommittee on Exam Development, we are saying to make policy recommendations to the full committee of bar examiners.
How many members are we looking for? And we have 2 subcommittees here. Phil.
So I
And
have.
how often do you expect them to meet?
We need this information from Alex.
Yeah, I did not have from Alex his thoughts on how many members.
hate to say this, but should we table this? So we can get Alex, because Alex is, this is really his project. Alex Chan.
Los Angeles, I'm sorry. Could you all speak into your mics? We're having difficulty hearing
Yeah,
you.
I'm sorry. My suggestion is maybe we should table this until Alex is available. This is his project.
Alex Chan.
Alex Chan, yes.
We can do that, and we can actually just put it on as part of the joint meeting that will be scheduled for early August. We can put this on the CBE part of that meeting, so the board wouldn't weigh in on it, but you all would, just so that we don't have to wait until October to get it done, because that's too late.
All right.
Because we do want the Committee on Exam Administration to start meeting so they can start having vendor presentations.
All right, let's do that. But please, let's start thinking about who wants to volunteer for this before we start drafting people. Okay, we don't need to vote.
Nope.
No. All right.
Minutes and consent.
Yeah.
Open minutes and open consent.
Yeah, moving on. Next on the agenda is approval of the open session meetings, minutes of the April 8th, 2025 meeting. Do we have any questions or revisions for the minutes?
I thought they all were fine, and I would move approval of all of them.
If you didn't attend the meeting, do you have to abstain, or can you still vote yes because you support what the minutes say?
You can still vote having, because you know that your other colleagues on the committee have reviewed the minutes and are agreeing that that is a accurate representation of what occurred.
Okay, thank you.
I think there
But
was
you don't have to.
Okay, thank you.
I think there might have been a typo in the May 5th meetings. Page 9, under 3 business 3.1, that first resolved, we have this like introductory paragraph and then a vote, but there's no like actual like language we voted on. So I think that might have been an accidental copy and paste from the resolved paragraph underneath it, if that makes sense.
I'm looking.
Stand by, we're looking.
And May 5th, page 9, if you missed the first time I said it.
This is for 3.1.
Correct. So that first one, it's resolved, and we have that introductory paragraph. And then, it ends with the specified parameters, and there's nothing there. And then it's just, the motion and vote. And I think that's maybe copied and pasted from the one directly below it, but there's no like parameters specified there.
So for that resolution, the committee voted, and this is what was voted on. So I think what was voted on there, was the typo then. But we had to accurately copy what was voted on, and the decision was to first take a vote to see if the committee wanted to recommend any remedial programs, and then they continued to individually vote on each parameter.
Okay, I might have forgotten then that we did a general vote to discuss it all. That's fine then.
Jean, is that your recollection as well?
That is, and this, if I'm not mistaken, this resolution was actually attached to the petition filed with the Supreme Court related to the additional remedies that the committee passed.
Oh, okay, that is my mistake. Sorry about that. Sorry, wasting your time.
No, good catch.
No. All right, so for 2.1, the April 8th, 2025 minutes, do I have a motion to approve?
Can I move all 4 of them at once?
Yes. But let's real quickly go through them then. What about the April 18th and 19th, 2025 open session minutes? Does anybody have any corrections or revisions? How about May 5th? Or May 30th? Okay, it doesn't look like there are any other first revisions or corrections. So Paul, if you want to move for all four.
Yes, I will.
Is there a second? Somebody? Anybody?
I'll second. This is Vince.
Vince Reyes is second. Devin, can you please take the roll? This is on all four, to approve all four of the minutes.
Dr. Bolton,
Yes.
Dr. Cow,
Devin, I will say yes to section 2.2, approval of the April 18th and 19th meeting. The remainder of the meetings I will abstain. I was not present.
Jean, if it's one vote, is that possible?
Dr. Cow, do you want us to break this out for each? As Donna described, you can rely on the representations
Yes.
of your fellow committee members.
Yes. Yes, then. I guess I will ruin the party and break it into 4.
I'll join the party.
That means 4 votes. All right, let's go back. Paul, do you want to make a motion for 2.1?
Sure, I move that approval of those minutes.
All right, is there a second?
James Bolton, second.
Thank you, James. James Bolton seconds. Devin, call the roll, please.
Dr. Bolton,
Yes.
Dr. Cow,
Abstain.
Kareem Gangora, not present. Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, not present. Justice Macy Walla, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Oh, yes, based on representations of the other committee members, so yes.
Alan Yokelson,
Yes.
Alex Chan, not present. With 8 yeses and 0 nos, the motion passes.
Do I hear a motion for item 2.2, the April 18th and 19th open session minutes to approve? So is there a move by Vince Reyes?
I'll second, Michael.
Second by Dr. Cow. Call the roll, please.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora, not present. Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, not present. Justice Macy Walla, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan, not present. With 9 yeses and 0 nos, the motion passes.
For item 2.3, approval of the May 5th, 2025 open session minutes. Do I hear a motion?
So moved.
Vince Reyes moves. Is there a second?
Second,
Paul Kramer seconds.
Kramer.
Kramer seconds. Devin, please call the roll.
Dr. Bolton,
Yes.
Dr. Cow,
Abstain.
Kareem Gangora, not present. Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Abstain.
Esther Lynn, not present. Justice Macy Walla, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Abstain.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan, not present. With 6 yeses and 0 nos, the motion passes.
Finally, item 2.4, approval of the May 30th, 2025 open session minutes. Is there a motion to approve?
So
I'll
moved.
move. I'll second that.
Who seconded it?
I'll
Julianne?
Julian. Yeah.
Julianne seconds. Call the roll, please.
Dr. Bolton,
Yes.
Dr. Cow,
Abstain.
Kareem Gangora, not present. Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Abstain.
Esther Lynn, not present. Justice Misiwala, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Yes.
Alan Yokelson,
Yes.
Alex Chan, not present. With 7 yeses and 0 nos, the motion passes.
Item 3.5?
Item
Or,
item 3.1 through 3.5, the entire consent calendar.
yes. Yes, next on the agenda is the consent calendar. There are 5 items on the consent calendar. Action on revised moral character administrative review procedures pursuant to Rule 4.46.1 of the Rules of the State Bar. Report on the administrative updates regarding law school. Action on a major change, voluntary termination of registration on May 31, 2025 for Western Sierra Law School. Recommendation of the Board of Trustees to extend the application fee waivers for withdrawals up to the date of July 2025 bar exam. And action on the Chapter 6 conduct violation decisional matrix. This is an omnibus item. Do any members wish to pull an item off the consent calendar? Otherwise, we'll vote together.
This is Michael. I'd like to make the motion to approve the consent calendar from items 3.1 to 3.5.
I'll second that. Alex
I
Lawrence.
have,
Okay.
I have a question about 3.5.
Paul, go ahead.
Yeah. About 3.5, is that person here? That's not Tara, is it?
It's Becky. We can promote her.
No, it's, okay. My question is, we're allowing people to upload answers up to 2 weeks after the time they should have uploaded them, right after the exam. And I'm wondering, if they do that, they'd be subject to a scoring penalty. But I'm wondering if allowing people to do that up to 2 weeks after somehow could slow down the grading process. I would hate to see that happen by virtue of us doing this.
That was exactly how it was in the Matrix before. And by and large, people upload their answers right away as soon as they get connected to internet.
Yeah, I would think there's no advantage in doing this. In fact, there's a disadvantage. So
Right.
presumably then it wasn't a problem before.
Right.
Okay, thank you. I'm willing to vote on the totality of the consent calendar.
All right, thank you. It's been moved and seconded. Devin, please call the roll. Devin, please call the roll.
Apologies, I was on mute. Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora, not present. Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, not present. Justice Misiwala, not present. Joshua Montgomery, not present. Bethany Peak, not present. Vince Reyes,
Yes.
Judge Reyna, not present. Ashley Silva Guzman,
Yes.
Julianne Smith,
Sorry, yes.
Alan Yokelson,
Yes.
Alex Chan, not present. With 9 yeses, with 9 yeses and 0 nos, the motion passes.
Thank you. Next is item 5.1, a staff report. Donna, do you or staff have any information to report?
We do not. We will defer this report till the next meeting. I think the only thing that I thought maybe we'd talk about was the July exam, but since I rolled that into the discussion of 4.1, no need for a further staff report.
Okay. That pretty much concludes our open calendar, open agenda items. Members of the public, we are going into closed session now. The committee will return to open session at the conclusion, but pretty much that will be to adjourn the meeting, just so members of the public will know. Substantively, the open session items have been completed. So with that,
I do want to say one quick thing, so sorry. Just because there's not a meeting between now and the bar exam, Devin will be sending out a message to all the members inviting you to visit the bar exam sites. So please look for that.
excellent. Dr. Bolden and I love to go to Pasadena site. Look for us there. All right, with that.
And if any members of the public are going to hang around, we do anticipate the closed session to end right about 5:30.
Thank you. Let's go into closed session. has concluded. Is there any more business? Anything to come before us? Seeing none, okay, this meeting is adjourned. Thank you very, very much, everybody. It was a long day and we accomplished a lot. Thank you, folks. Bye-bye.